The Assembly Committee on Government Affairs will come to order. Madam Secretary, please call roll.
Assemblywoman Anderson. Present. Assemblywoman Black. Here. Assemblywoman Brown May. Here. Assemblywoman Considine. Present. Assemblywoman Dickman. Here. Assemblywoman Duran. Here. Assemblyman Ellison. Assemblywoman Martinez. Present. Assemblyman Matthews. Here. Assemblyman MacArthur. Here. Assemblywoman Thomas. Here. Assemblywoman Torres. Chair Flores.
Present. Madam Secretary, please let the record reflect Vice Chair Torres is absent excused. And please mark her present as she makes her way into the committee room. And members, good morning. We will be taking the agenda out of order. We'll be doing Senate Bill 254 first, followed by Senate Bill 150. I want to remind for those of you who intend to testify this morning that you please state your name for the record and spell it the very first time you testify to ensure that we help our staff who are following along but are not necessarily watching the meeting. I also want to remind folk who wish to participate in public comment, we'll be doing that at the conclusion of today's meeting. And with that, I am reminding myself to silence my cell phone. If you could please do so yourselves. And with that, we'll go ahead and open up the hearing on Senate Bill 254. Senator Neal, whenever you're ready.
Thank you. Good morning, Assembly Government Affairs and Chair Flores. Thank you for scheduling this bill for hearing. SB 254 has been a journey, to say the least. So there is a lot going on. I never imagined that housing and trying to protect housing and trying to give equal rights and status to individuals would give me such pause for concern about all of the entities who care and who oppose. And this is one of these bills that, as I picked up and adopted source of income, caused an even wider strain on who was opposed and then who is no longer in support. And so as you guys go through this bill, and as you listen to who's in opposition, I need you to listen clearly on why they're in opposition, because there are certain amendments that were made that made them go into opposition. When we think about housing and we think about housing vouchers and we think about what they mean, right? We think about Section 8, we think about how they have had implicit bias and all of these things associated with it, the welfare mom. But yet it has been going on for 50 years or more, right? But it is one of the key provisions that in my proposed conceptual amendment, I excluded in the protected source of income because it's already going on. But the folks who are in opposition are just like, they believe that because I put in the exclusion, if anything happens at the federal level, that may make the feds see the state statute, right, as something that is a barrier and prevents us from being in alignment with any additional changes. I agree with that. However, to get to the place that I am now, to have this hearing in front of this committee and to discuss this bill, I had to get to a place where I at least was trying to insert and codify existing activity, excluding Section 8. And I wanted to put that out there because as you guys go through your conversation, and I don't know how you guys do it in this committee where you're allowed to talk to opposition and ask questions, get into the meat, get into the opposition and why, right? Because I did agree that in the interim, I would work on Section 8 and try to come to a place of what makes sense. So I'm saying all of this because it's very, very important, because sometimes when we hear opposition, we're like, oh my God, she hasn't really worked out all the issues with this bill. But I've worked out 95% of the issues with this bill. That is a key provision that I think is subject to debate. It's always been subject to debate. But the majority of the bill that you have in front of you, I think, gets at the place of creating stability for ex-felons, people who have served time, people who have been burdened with an arrest, and trying to at least allow the conversation and the statutory protection for stability to find housing. It is the most important thing in the world to be able to have a roof over your head. It can be the most unimaginable experience to be able to have to exit from a facility and then find out that you're in a reentry program, but in all of the grace and the love that people have for you upon your release, and then you find out you cannot put in an application and you cannot have an apartment. We're not even talking about a mortgage. We're just talking about an apartment. And so this bill does that. It has some exclusions. It excludes all sex crimes. And when I talked to the women who were ex-felons who I had meetings with, they agreed with that. It excludes all violent felonies. Everything else is in. And the reason why I had to make those changes and make those adjustments are because people have a natural fear around who is living next door to them. I understood that. I recognized that. And when I talked to Professor Pendel and he talked to his senior parents, he's probably going to be mad at me for saying this, but one of the things that they said were, what if, such and such was living next door, right? The serial rapist or serial murderer. That's a problem. It's a problem for all of us because you don't know who it is. I also included arson. And here's the reason why. At first I was totally like, yeah, I don't know if that's a big deal, right? Second, third, fourth degree. But then right before I think my bill hearing, either right before my bill hearing or right after my bill hearing in the Senate, some lady burned down her apartment. I was like, okay, that might be a real thing. I don't know why she did it, but apparently she put everybody else in harm's way because she set a match, burned up her place. So that is a problem, right? You don't ever want to be anywhere and the smoke alarm is going off and it's 2 apartments down the way and you're trying to figure out, let me grab the cat and a bottle of water, make it out. So the bill is a good bill. And so I'll let Professor Pendel go because he is my co-presenter. But the bill also aligns us with HUD. If you knew the journey in this legislature, and you guys will know because a lot of you guys, this is your first session, but as you go and spend your 12 years in this body of awesomeness, you will go through so much struggle on your legislation. But believe it or not, housing has been a part of the Nevada Legislature or trying to get to a place of substantial equivalence with HUD since 2009. There are portions of the bill that 35 other states have done. They have accepted HUD's willingness to partner and willingness to investigate and resolve housing discrimination at a state level. And so I'll get into those provisions of the bill, but I wanted to say that because there's a history of this, and there is no state that has moved in the position for the ban the box provision that's in the bill. There have been cities that have passed ordinances related to ban the box, but they have not been at a state level. So this is a big deal. And I'm carrying this because I ran into so many women who are part of the underground of ex-offenders who literally, there's one woman, she had been released for 7 years and she had not been able to get an apartment in her name. There's an apartment in her child's name, which is potentially illegal because it's a minor, apartment in her mother's name. And then prior to that, she was couch surfing, right? So she was on someone else's couch after release. This bill will allow people like her to be able to exit and then put in an application and be viewed equally as you and I, to say that I have an equal right to put in an application and potentially be housed. The bill does not exclude if you go in the apartment, start being rowdy, acting like a crazy person, and you violate the rules of the apartment, you will be evicted. The bill doesn't touch that or get into any of that at all. And so I will leave the remarks right there because I woke up with opposition. I went to sleep with opposition. And now I will turn it over to Professor Pendel of Boyd Law.
Thank you, Senator, and I appreciate you saying this is a good bill. You know, so many times we have presenters that come in here and present bad bills, but you, Senator, not you. I appreciate you, Professor. I'm not looking at Matthews, but I'm looking at Matthews. I'm kidding. Professor, good morning. Just some light-hearted humor. Professor, whenever you're ready.
Okay. Good morning, everyone. Let me share my screen. So I have a PowerPoint to present. Okay. So my name is Nagai Pendel, Ngaipindell. I'm a professor of law at the Boyd School of Law at UNLV. And I wanted to make clear that I'm also a NERC commissioner, Nevada Equal Rights Commission. But my comments today are as professor and not as NERC commissioner. And then last, wanted to say hello to all of the Boyd alums on this assembly committee. It's good to see all of you. So I wanted to talk mainly to Senator Neal's bill, the portions that point to fair chance housing and the opportunities for those formerly incarcerated. So Nevada has an extreme shortage of affordable housing, as many of you know. So only 18 affordable and available homes per 100 renter households. So the challenges for all people, not just those formerly incarcerated, but many are extreme in Nevada. But we're talking about those formerly incarcerated. And what I want to emphasize is the effects of mass incarceration on communities of color. There is a book that was just published this spring that emphasizes the timeliness of this issue. So Reuben Miller, who is a University of Chicago professor, talks about the effects of mass incarceration on families and communities of color. And one of the, two kind of poignant examples. One is, he mentions the number of people that live with a felony record and their racial composition. But second, he also mentions that his inability as an accomplished person to help his brother, who has a criminal record, find housing. His brother couldn't live with him because he lived in faculty housing that didn't allow people with criminal records to live there. And he had trouble finding other places for his brother to live. So even somebody with means and is relatively sophisticated could not help his brother find shelter after being incarcerated. So again, the effects of the criminal justice system are disproportionately borne by communities and people of color. So Seattle, another city that is considered the Fair Chance Housing Ordinance, rooted a lot of their discussion and then the reason for passing it on the disparate impact on racial minorities that a ban on people with criminal records and housing would have, or not a ban, but landlords being able to consider that. This disproportionate impact on communities of color has also been recognized by HUD. So the Office of General Counsel, this is guidance to landlords about how they might take into account criminal records in their admissions process, acknowledge that criminal records-based barriers are going to have a disproportionate impact on minority home seekers. We're under the Fair Housing Act, what we're concerned about is a disproportionate effect on racial minorities, right? So does the application of a law or a practice have a disproportionate impact on racial minorities? And if it does, it's perhaps a violation of the Fair Housing Act. And of course, intentional discrimination is a violation of the Fair Housing Act. So we're looking for disproportionate effect or intentional discrimination. And then again, HUD recognizes that when individuals are released from prisons and jails, their ability to access safe, secure, and affordable housing is critical to their successful reentry to society. Senator Neal gave you one or two examples of people that she talked to that had served their time and had paid their debt to society and nonetheless were hampered in their ability to find housing after conviction. This is my last slide, and I'll start with she mentioned my parents. So we've had many conversations about this bill, Senator Neal and I, and when I've talked to others, we have a justifiable concern about who's living next door to us, or if you think about parents, right, it's who's living next door to their children, right, when they are in an apartment somewhere. And so, after thinking about those kinds of concerns, as Senator Neal said, she excluded violent felonies, sex crimes, and arson from the bill. But this is good policy, right? It increases racial equity in housing, keeping families together, lowering the risk of reoffense for those that have, again, paid their debt to society. And we know from the last year that stable housing is the center of a strong and inclusive community and central in our public health response to COVID. So today, more than ever, we're aware of the importance of housing and shelter, not only to families, but to our communities as a public health issue. So again, I think fair chance housing is good policy, and I hope the legislature passes this bill. Thank you very much.
And thank you for joining us this morning, Professor. We'll come back to Senator Neal.
Thank you, Chair Flores. All right, so now I'll go through the bill. I'm sure you guys have questions. So the sections 1 through, I'll pretty much say all the way up to probably 32. Those codify the HUD provisions. NERC is currently statutorily unable to enter into certain agreements with U.S. HUD for the Commission to investigate and enforce laws relating to fair housing as a certified agency under federal law. The provisions that we are placing in here helps to allow them to do that and places them in a position to not only receive support from HUD, it would allow them to receive additional investigators and an attorney that would help them handle cases at HUD. And so those provisions, and we can go through those if you guys have questions on those, but it helps us to get into a position as a state to number one, align, 2, get support, 3, update our laws so that we're in compliance. If you notice in the provisions, we're literally, this bill is adding familial status and religion. You're like, okay, I thought that was already in. Well, apparently not in Nevada. And so we're able to adopt this language. And so I was willing to take that on to be able to assist NERC in trying to get to the place of substantial equivalence so that HUD would come in and support the state of Nevada with some financial support and also just to simply get us in alignment. When we get to section 31, 32, and 33, these are the provisions that, well, there's an amendment on section 33, but these are the provisions that get us into the, I would say the felony provisions or the ban the box provisions that I have been, which was the heart of my reason for bringing this bill. So in section 31, you have the aggrieved person. In section 32, what's unlawful discrimination. And then when we get into section 33, this is where we have some amendments. So in section 33, everything is the same except for when you get to section 33, subsection 2. So the amendment of the provisions is set forth where, I think you guys have this in Nella's, to provide that a person who inquires into or conducts a background check in accordance with subsection 2 is authorized to refuse to rent or lease or refuse to negotiate for the rental or lease of or otherwise make unavailable a dwelling on the basis of an arrest record, conviction record, or record of criminal history only to the extent authorized by federal law. So there are already things in place in federal law, and so we're not messing with that, but we are creating some caveats within the state that don't get into preemption or don't get into other issues where we violate already established federal rules. Once you get into the it's sub after that sub 2 and you get into A, B, C, and D. This lays out the first degree arson, the first, second, and then the violent offenses that I spoke to. As you go further down, this deals with if the rental or lease is being made available by a public housing authority, and the public housing authority has adopted a policy to use such offenses. The only thing I believe what I excluded was, so whatever's in place for at the federal level that's a revolving HUD or the housing assistance, but I did do a carve out for marijuana that's in the state of Nevada because we've legalized marijuana. And so because we've legalized marijuana, I didn't want anybody to be denied on a drug offense if it was marijuana and we had made it legal in the state of Nevada. And so marijuana is in, but if there are other drug-related offenses, if you guys are familiar, there are drug-related offenses that you cannot get into public housing on certain drug-related offenses because that's federal. So that's what that provision speaks to. And then when you get into sub 3, this is the person who makes the dwelling available for rent or lease and is subject to this provision shall provide to each applicant. And so this is the provisions of 118 and 118, NRS 118 and 110. But it basically talks about how the applicant may appeal a denial for a rental or lease of a dwelling in a public housing or public housing authority. Then we go into how the applicant may file the complaint. Then, and what it does not apply to. So the provisions, if you go to page 23, sub 4, lines 5 through 15. We talk about that what it applies to. So this applies to the dwellings that it does apply to. And then you have in sub C, which is line 15, this is what it doesn't apply to. So, and I want to make this clear. It doesn't apply to single family residences. It doesn't apply to manufactured homes. And it doesn't apply to dwellings that are smaller than 4 units. We were trying to make sure we were going after the larger apartment complexes and trying to make sure that the door was open. So if you look at sub C, do not apply to any of the actions. This is where it says any of the actions taken by the person pursuant to any federal law or regulations that require the person to inquire into the conduct or background check to determine arrest record, conviction record, or criminal history of an applicant. It excludes, this is where we get into the sex offenses, which are all sex offenses. We just kind of just put that all the way in there. And it also, these are where the exclusions that I just mentioned about the manufactured homes, single family housing, etc. When you get into the latter part, that's where it's talking about the arrest records and how those are going to be applied. And then when you turn the page, we get into background checks, which means any report regarding the arrest record, conviction record, or record of criminal history of a person intended to obtain a person's record of criminal history, conviction record, and then the definition of dwelling. And then we have public housing. And then when we get into 33.5, which is another amendment, 33.5 gets us into the source of income, which some folks are neutral, and then because of the amendment which you guys have on Nellis, so the amendment that you guys have on Nellis, which amends section 33.5, basically says that for the purposes of the prohibition on discrimination based on source of income, the term source of income is not limited to income from a federal law passed for the purposes of providing relief for COVID-19. Instead, the definition of the source of income would include such federal funds, just as one example is the source of income. Specifically, it revises the definition to mean housing assistance or benefits paid by any federal, state, or local government entity before June 30th, 2022, including without limitation any rental assistance funds provided pursuant to a federal law passed for the purposes of providing relief for COVID-19 pandemic. Section 33.5 also amends subsection 3 of the bill, provides that if a landlord requires that a prospective or current tenant have a certain minimum level of income, the standard for assessing eligibility must be based only on the portion of the rent to be paid by the tenant, taking into account the value of any federal, state, or local rental assistance or housing subsidy. Additionally, the bill provides that a person who makes available a dwelling for sale or rent is not prohibited from taking into consideration the sufficiency or sustainability of the income or the credit rating of the applicant or the prospective buyer in a commercially reasonable manner. The amendment will maintain this provision so that a person who makes a dwelling available for sale or rent may take into consideration the sufficiency and sustainability of the income or credit rating of the applicant or prospective buyer, so long as these factors are applied in a reasonably commercial manner. The amendment continues to say it removes section 45, subsection 3, so the provisions of section 33.5 prohibiting discrimination based on the source of income do not expire on June 30, 2022, and will continue to operate beyond the date. So what does all that mean? What I tried to do, working with stakeholders, was to find a very unhappy medium where we could get to the place of at least protecting existing activities that were already going on. So for me, that sentence where it says specifically revise the definition to mean housing assistance or benefits paid by any federal or state or local government entity before June 30th, 2022. We already have people going to seek assistance from HELP, right? If you've ever gone and tried to get a voucher from HELP for first month deposit and then first month's rent, I wanted to protect what was already going in the space. What the stakeholders asked for was a specific exclusion to Section 8. And that specific exclusion to Section 8 then caused my support to then move and switch to an opposition position because of the statement that I made earlier, which they felt if I do the exclusion, how will the federal government see that exclusion in state law and then view it negatively, where then we're maybe in conflict, and now the statutory provision is telling the feds what we're doing in the state, and then there's some kind of okay, well, we're not going to necessarily apply this, or we get into a conundrum where we are being asked the question, do you support Section 8 or not, right? And I think that's a valid point that's being made. My hope was, or what my intent was in excluding Section 8 was it's already going on. I didn't go into the statutory provisions to eliminate it. It's already a practice. It's already happening. And so it'll be this committee to determine if that's true. I did, I don't know if that's, hopefully that was my intent, to try to get there, not to codify Section 8 in state statute, but to leave it as is, as to how it's currently functioning right now. So the rest of the bill is pretty much from 38 to 30 to the rest of the bill is the HUD conforming pieces. And so I'll just open myself up for questions. The bill is a lot, and there's a lot of backup that I have associated with it. So, Mr. Chair, let's rock and roll.
I don't know if rock and roll is the right word, but we'll see. We'll see. We'll let the party get started with Assemblyman Matthews.
Thank you, Mr. Chairman. Thank you and good morning, Senator. Appreciate the presentation on the bill. You noted in your introductory remarks that initially arson was not among the exclusions or the exemptions in this bill, and then there was this incident, and that's what sort of sparked its inclusion. And so, my question would be, would that not sort of underscore, the fact that government in general, but especially here at the state level, is simply not omniscient and simply cannot anticipate, every circumstance? And after all, if this incident hadn't occurred, we may be sitting here today with that exclusion not in the bill. And it would seem to me that this would sort of highlight the folly of, especially at the state level, government trying to impose sort of a top-down, one-size-fits-all approach and substitute its judgment for perhaps local governments, or better yet, property owners who have more practical experience with these things and the challenge that arise, who are closer to the situation locally, and ultimately do bear the risk, for the problems and the challenges that may occur. And so I'm just wondering if you could speak to that in light of that incident and the history of this bill. Thank you.
Thank you for the question, Assemblyman Matthews. So you make an interesting point. Yes, to a degree, recognizing that arson was an inherent, danger. That's why I included it. But I also feel that I'm not impeding on an apartment or a private, apartment complex to deal with or have the discretion that they would like to keep, because I feel like it is in the best interest of the state to engage in this public policy and to take state action in regards to fairness and fundamental access to the ability to have a roof over your head. So when we talk about fair housing and we talk about the right to housing, I wanted to assert that there is a right to housing. And because of that, I chose to put in a bill that would then set parameters and lanes around how that discretion is applied, because I felt like the state had a legitimate interest in getting involved in this issue because of the level of people who are found without a home, who are homeless, right, who find themselves on the street, still having to, number one, take advantage of government services to take care of them. So that I felt like in the circular argument that we actually win, and we are actually better able to take care of our citizens by providing a pathway for individuals to get housing. One thing I know for sure, federal programs right now, we currently are putting millions and millions of dollars into reentry programs in order to allow those persons in order to get back into society and get a second chance. Supposedly, we believe in a second chance. And we have put that out as a public policy purpose of the state. We've also put millions of dollars behind that purpose. But at the end of it, we've said, oh yeah, but you don't get a second chance at a house. You actually don't get a roof. And that is disingenuous to me. And I felt that the state needed to get in a position where we were going to speak on that, because it also is a good investment to put our dollars in the right place. Because what we're saying is that we'll give you job training. We'll spend hundreds of dollars on you to get a job, but you got to live on the street. It doesn't logically connect to say that that is what the purpose of government is, to say that it's all right to release you, it's all right to arrest you, and then if you don't even have a conviction, use that arrest against you and then say, but not this apartment, not that apartment. You go live with your mama. You go live with your cousins. That is not what I felt what should be going on, because what I found out in the space was that that is what's going on. And I was just like, so what are we spending this money to do if ultimately they're not going to find a house. And so these concerns that I'm eliciting right now were my overriding concerns, where I felt I will step in on the discretion because of the greater service and public policy purpose that I felt needed to be established around housing.
Thank you, Senator. Thank you, Mr. Chairman.
Thank you, Assemblyman Matthews. Next, we'll go to Assemblyman Ellison, please.
Oh, thank you, Mr. Chair. And happy to see you again, Ms. Neal. I've been trying to get down there to say hello, and it was a great honor to see him show respect to your father on the floor. So I
Thank
wanted
you,
to get that
Assemblyman
out.
Ellison. I meant to say hi to you yesterday, too, when you presented in Senate GA. So, good morning.
Yeah, good morning. Hey, I got a question, and we both know that there's a shortage of public housing out there right now, and actually it's kind of in some areas it's critical. One of the questions I have is, I understand when I read some of these reports right here of the requirements that some of these people or apartment complexes have. But my biggest thing is the single mothers and the mothers, the children, and that should be priority in every public housing. I don't care what it is. That should be first come, first serve, I think, because it's kind of rough on some of those that might have 3 or 4 little kids and try to get them to school, try to work, and trying to find a place to live. I think that should be the number one. But then when it gets down to, you said just now that everybody, once they pay their debt to society, that should be done. And I agree with that. But I think they still need to go through a process, a small process, and get there. And I did have an apartment complex burnt down by a woman that was getting Section 8 money because she got mad at her boyfriend and took it out on my building. So, been there, done that. But she did, I think, a month in jail for total destruction of a building, and it almost killed 10 people. But that's not the issue. The issue is, I think we need to prioritize some of the people that get to go in there, and maybe I'm wrong for saying this, but I still think that they should prioritize the mothers first, and then come down from there and look and see if they can help those individuals. But you're right, there is a shortage of housing, and I don't know what they're going to do to eventually get there. But I do believe that people do pay their debt to society. I believe that. But I still think it has to go through a process. But I looked at some of these that were in here that restricted them. Child molesters, you took that out. And some of them should be, eventually, they still need their debts paid to society, and they got to be watched. But maybe you can hit on what I'm trying to get at, but see what my problems are.
So, thank you, Assemblyman Ellison, and I respect your opinion on this. But so you said a couple of things, and I understand the thought. Couple of things. When you said prioritize, and I'm going to work backwards and get into a lot of it. So, number one, you said prioritize single mothers and give them a priority. Here's the reason why we can't do that, and why the bill won't do that. Because we only have certain classes of people in which we give priority to, right? We don't want to ever get into an equal protection issue where, number one, we're giving a class of people higher priority over others. We have already established in law around ex-offenders. And we have dedicated funding and resources to ex-offenders. And I'll make give you one example on how we have focused on rehabilitation even when they're in NDOC, right? So in 2015, I passed a bill that literally focused on the last 18 months that they're in NDOC and what is supposed to be happening with them in regards to training, ability to get them ready to exit. There were millions of dollars being spent in NDOC right now in order to do reentry work before release. And typically, the most, I I would say the most strenuous activity happens within that 6 months, right? Because you could have within the system a reoffense that rolls your release date back. But within that 6 months, when you know that you're getting ready to get released, there are monies that are being spent, federal and state, in order to get you ready to exit. We then, in the South, have Casa Grande, which is a housing where they're in a kind of like a halfway house, and then they're allowed to be in that halfway house and then try to get on their feet. At the same time that that's happening, we are using WIOA dollars and workforce dollars to help these individuals get trained and then reestablish themselves. We're doing soft skills, we're doing hard skills. We are trying to do some level of mental health preparation, but we are putting millions of dollars into this category of individuals in order to help them get their second chance on life and then be able to live. With that said, those individuals have already gone through a process, and we have paid for it as the government. Now, the question is, what should be the state's position in regards to those individuals then being able to get a house and really be independent and work? Because if the idea of the state is that we should spend all of these monies and these services, wraparound services around ex-offenders and reentry persons, and then when they get out of these programs where we are helping and assisting, then tell them, go get your sleeping bag, pull up a couch, or go sleep over at a friend's house, but never allow them to use the money, which we said that they had the right to earn, and paid money in order to get them ready for the work that they are doing, and then tell them, but no, you cannot put in an application and put in a deposit and get an apartment and live on your own. I think that it is the best policy of the state of Nevada to help those individuals to be able to live that life that they deserve. Nobody wants to continue to pay for their prior mistakes. If they run into another crime, Assemblyman Ellison, they will go back to jail. This bill does not debate that or argue that. But if you say that you're rehabilitated and you're rehabilitated enough where you are getting a release from NDOC, if you are arrested and you're not able to, the DA is not able to sustain a charge on you that keeps you off of the street and you are free because the conviction was not found, that arrest should not limit you from going in and having the ability to put in an application, pay your $250 or whatever it is for your deposit, and then have a roof over your head. I think housing is a great stabilizer. And I want to make sure that everyone is stable.
Follow up, Mr. Chair.
Follow up, please.
Well, what I'm trying to get to is right now, one of our most critical deal is senior citizens. Our age, there's more senior citizens out there looking for housing than anything. Then the second is families that are trying to get in there. So if they don't have a place to stay and we open it up for anything and anybody, we're going to run out of housing right off, are we not? That's my biggest fear and I can understand the restrictions on some of these because they just come out and they're trying to get back in, but maybe they need to look at if next building housing, they need to start in smaller units and more of them for reasons for this. But I still think in my heart that it should be seniors first, mothers with children second, and then down the line. It's because if not, where's our seniors go? And that's my fear and that's why I say prioritize. It should be our elderly, and then the families should be next, and then from there down.
And thank you for that comment, Assemblyman Ellison. And listen, we served on Assembly GA for a really long time together, and I respect your opinion, but this is just where we differ. Yes, senior citizens are a priority, but ex-felons are not less than. They're not less than people. They're not less than any other group. once they become released, it should not be the state's position to say that an individual is less than because you have a record. Because if we are saying that, then we're in a whole other category that's of issues. Because we did pass ban the box for jobs in 2015 under Assemblyman Tyrone Thompson. We did do that. And the reason why we did that is because the state made a public policy decision that reentry persons were not less than, that they actually had an equal right to apply for a job just the same as someone else who did not have a criminal record. And that was a very significant policy. This is the same thing in terms of you can apply, but don't use my criminal background against me and then tell me that I am not allowed to live in a place and therefore I am unequal. Because if we're saying that, we have some really moral questions that I think we need to ask ourselves about who is equal and who we have designated as less than in the state of Nevada.
All right. Thank you, Assemblyman. Next, we'll go to Assemblywoman Brown May.
Thank you, Mr. Chair. Thank you, Senator Neal. It's fabulous to see you here today. Applaud your efforts. I have a couple of clarifying questions. I think it's just important. First, on the very last slide, you have access to stable shelter is a public health issue and critical to effective response and recovery to COVID. I agree with that.
Which slide? Is this my slide or Professor Findell?
It's
this
probably
is Professor
professors,
Findell.
right?
Yeah.
But fabulous. I mean, I
Okay.
think access to fair housing is very important. And I've heard a couple of comments, so I just really want to clarify. My colleague stated public housing. This is not relative to public housing, is my understanding. This is like all housing, all apartment complexes, all renters. Is that correct?
This is minus the exclusions in the bill, yes. I mean, well, it's all of the privately, commercially owned apartments or housing. I'll just say that.
Thank you. Follow up.
Please follow up.
Thank you. So I'm curious to know, do you have a number? What is the scope of the number of people that this would affect in Nevada? Do you have any idea?
Professor Findell, do you have data on that? I personally had a group that I met with, but I don't have the direct statistics, but I had a group of women, 20 ex-offenders that I met with over the summer, and that's when I understood the global part of this in terms of who was affected in this underground group. But the direct stats, Professor Findell may have it, or we may be able to get that back to you in terms of who are the ex-offenders, because I did have that number ready in the Senate GA hearing, but I could not find my bag of notes. And I do have that number and probably could be able to get that to you in about an hour, because there is a set number of re-entry persons who are in the state of Nevada who this could affect.
Thank you, Senator. And then one last. I heard you say in your comments, arrest and then conviction. And it's been a while since I filled out an application for an apartment, although not very long. And you've said ban the box now a couple of times, and I appreciate that. I just want to be really clear. The box on that rental application that we're talking about, what does that state? Does it state arrested? Does it state convicted of a crime? Can you just clarify that?
So, because I recently did fill out an application to move up here, and I believe it had conviction, whether or not you had been convicted of any crimes, and you check the box, no.
Thank you, Senator. I appreciate that. Thank you, Mr. Chair.
Thank you, Assemblywoman. Next, we'll go to Assemblywoman Considine.
Thank you, Chair, and thank you, Senator Neal. I love the intention of this bill. I really, really do. I'm confused in some parts. I know I have a lot to kind of still get through reading the amendment, so I have just a couple of questions. One of them is, what I don't see in here is if a landlord does a background check, do they do a partial background check on just those things that are required in here? Or is a background check a background check? And then as a landlord, I can get a background check and say, okay, well, none of these issues that I can use, or I can, as a basis to cross this person off for this apartment. But there are other things now that I see, like an arrest or something that shouldn't be allowed under this bill. How do you enforce that, I guess is my question. Is there a specific way that you can background only for the things? Or if not, how do you enforce it?
So in regards to that, and I think that this is probably best by someone, but the way that I've envisioned it is that you just run a background check, and then the exclusions that are out there. So there are already federal rules in play and what you cannot use against someone already. So if you, in the way I envision this happening, you run the background check, which they say is all electronic. You get this sheet, and they say that and then you see these exclusions, like, okay, maybe there's a sex offender. That person is then triggered to say that this is probably going to be a denial. You see a violent burglary with a weapon, that would then trigger a denial. But then everything else is not going to be a part of that, right? So whatever those violent felonies exclusions, there's going to be some level of education around apartment managers in order to say, here are the new rules that we're playing by, here's what the feds have said, and then here are our practices that we now have to bring in. That's the way I see it going, that it will be a whole check. These things that we have carved out are then the exclusions, and then the person is at least able to put in their application and not being denied on what is currently going on as best practices, I guess, by the apartment association. The way that I understood it is that they have a series of practices that each apartment complex may or may not have had on the list, right? So one apartment could have had X, one could have had Y, but they followed best practices from the National Association. This circumvents all of that and then says, here's everything that's out and here's everything that's in. And so the way I assumed that this was going to happen is that they were going to educate, sit down with their apartment managers and have a discussion on how things were implemented. And here's why I think this is going to happen this way. When I had another bill in 2017 that pretty much went after workforce agencies, and it changed the way that they function. We all got in a room and we talked about the implementation of the law. And we talked about how it was supposed to work and what then are the requirements of them now, after the bill, it was AB 354, what they were now responsible to do. They got all of their questions out, and then they started to do the practice of implementation of that bill. But I think apartment association would be better to answer that question, but that's the way I interpreted that it would be. I don't know if NERC could add any review there in terms of, like, if there is an appeal, how that would then be dealt with, because it does speak to it in the bill, like if there's a complaint and you're supposed to do conciliation first, and then that backside of it, if that is also something you want to try to examine and get on the record, I think that NERC would be able to explain at least the back part, and then the front part, the apartment association. But that's how I envisioned it, that when the bill passes, you then put little regs, you have notices in your apartments, and you put these exclusions out there.
Thank you, I appreciate that. And if NERC wants to answer, because what I'm envisioning is, let's say you have two people that are applying for an apartment. You do background checks on both. Neither one of them have any of the crimes listed in there, but one of them has, a conviction for nonviolent crime. And you're looking at those. If I am that person and I am not picked, how do I then contact HUD or NERC or whoever and say I was, discriminated against because of this? How do you, I guess, prove that?
So I'll let Ms. Jenkins direct that. But there are provisions in the bill, but I'll let her talk about it and I'll point to them. Ms. Jenkins? So if you get a complaint, go ahead.
All right. Well, thank you so much, Senator Neal. And good morning, Chair Flores and members of the committee. It's me, Kara Jenkins, Karajenkins. I am the administrator for the Nevada Equal Rights Commission. And if it's okay, Chair Flores, through you, may I address the committee member directly?
Please do.
Okay, perfect. So it was a great question, and I was sitting here taking notes. As Senator Neal had mentioned, because we've already had Ban the Box pass through a prior session, NERC provides training to employers on how to equitably reject an applicant for a job. And I'll get to housing in a minute. I'm just going to run a parallel real quick to how to, in equity, deny an application for employment, even though we're making sure that we're not using criminal background behind them. And it only relates in Nevada to public employers. Okay. And so we train on how to send conditional offers of employment. And then once an employer conducts a background check, and they find that there are certain elements or certain crimes that are not within the protections of equity and NRS statute, there's a way that you can let them down. And so similarly in parallel to a rental application for an apartment. As Senator Neal had mentioned, there are carve-outs, right? Sex offenders, violent felonies. So if someone had committed murder and then wanted to rent an apartment, I would imagine that apartment complex would have every support under the law to just say, sorry, you're not accepted. It's similar to the first and last month's rent requirements. So just want everybody to just think about, even like with employment, when you apply for a job, or if you apply for an apartment, you have to meet everybody's got to meet certain elements. First, last month's rent, be able to prove that you can afford the rent. And then on top of it, you have to just basically make sure that you'll be a good tenant, right? Or a good employee. So if someone feels like, and I'm going to take a seat here. If someone feels like they have been, they've met all those requirements, they do not have a serious felony criminal background, they're not a sex offender, but they otherwise got rejected anyway, they would file with the Nevada Equal Rights Commission. They could also file with HUD. In fact, most people do file with HUD because we don't have the substantial equivalency. Most Nevadans do go to HUD or they go to our nonprofit partner, Silver State Housing. Hopefully that will change. But they can file a complaint with us and then we'll conduct an investigation. I hope that makes sense. And so the investigation would probably just look at the statute, the law, just to ensure that, okay, in doing the background checks, was the law followed? I don't want to get too deep with this. There's just a lot, but yes. And if their law was not followed, if say someone had a misdemeanor or an arrest, noting that an arrest is not a conviction, then we would pursue conciliatory efforts to settle. And it'd be a quick turnaround because the longer someone's without a home, the more detriment to that person, to that Nevadan. So I hope that answers your question, maybe some more follow-up, or if you have any more in-depth questions. Essentially, the person could, if they felt like the laws weren't followed, should this bill become law, that they had a non-violent felony or maybe they had an arrest, but yet they could still meet all the other requirements of the apartment complex's rental application, yet they still couldn't get in, and they feel that it's because of their criminal background that they were denied. They have to file a complaint with NERC or HUD, San Francisco, and we would do an investigation and try to settle the matter.
Thank you, Ms. Jenkins. And Section 14 lays out that entire process. So if you go to Section 14, it talks about the conciliation, what happens with the complaint, what happens at the hearing. If you go to, it continues on. Section 15, it talks about probable cause to believe that you were unlawfully discriminated against in housing. It talks about the role of the Attorney General in Section 15, Sub 3. It talks about the preponderance of the evidence standard in Sub 5. Then it talks about the injunction when you go to Sub 5, sub C. And then it continues if the court rules. And then when you turn and go to section 16, it talks about the power of the order and how if you do the alleged complaint, the order's issued. It talks about then your ability to deal with the final decision and requesting judicial review. And then it goes on to talk about pretty much kind of like the civil procedure that would happen, the cross petition for judicial review. And then on section 7, what then the commission is responsible for doing after that judicial review. And then it continues on in section 16 on page 9, where there's a full laid out about what happens with the petitioner or cross petitioner who's seeking judicial review, how they serve and file a memorandum of points, and so on and so forth. And so the bill is, I would say, very prescriptive, and these provisions get us into the substantial compliance, which Ms. Jenkins was talking about, that gets us to the place where instead of going to HUD San Francisco, NERC Las Vegas. And so if we adopt these provisions, which is very important for us to get in alignment with HUD to get in NERC to get on the same page as HUD, that then allows the person who was affected to have the statewide ability within Nevada, just Las Vegas, and then whatever NERC offices, which are in the north as well, to be able to bring this complaint. And so these provisions are very important to the bill because it opens us up to deal with what's going on in our own state.
Thank you very much, and thank you for that explanation as well. My other question is on the amendment, the additional language in the amendment. Nothing in this section requires a landlord to qualify the subject property to accept federal, et cetera. That last line that says use a particular form of rental agreement, if you can explain what that means or why that was put in here, I'm just a little confused on that. And that's my last question. Thank you.
Where is that? Is that which paragraph? 1, 2, 3,
So I'm
4,
looking
5?
at the amendment, the language in blue, and it starts with, it's under your subsection or section 2. It says nothing in this section requires a landlord to qualify the subject property to accept federal, state, or local funding, that's section 8 language, or create a duty on the landlord to perform any kind of reporting. And then the last sentence, or to use a particular form of rental agreement. That's
Okay.
my question. I don't understand where that came from or what that means.
Let me pull that up. But I can tell you that that was an agreed upon language. Because I think I have, let me pull up the one that you guys have on Nellis.
Conceptual amendment that was just put on Nellis. Okay.
Which I believe I have less blue language than what you have. Because I did several changes.
So it's at least on the one that I'm looking at, that's on the one I got on Nellis, subsection 2, second paragraph. Or section 2, second
It's
paragraph.
not limited to. So I think I have, because the one I have, amend the section of, so my sub 2, if you're in, amend the definition of source of income, that's what it begins with? Because
The-
that's my sub 2.
Right, so then I have on this one a paragraph right below that paragraph.
Amend section 33.5 subsection 3 of the bill that provides if a landlord requires.
Okay, I have a paragraph above it.
Oh, that part, nothing in the section required, that came from the Realtors Association. They asked for this change. So nothing in the section requires a landlord to qualify or accept. So they wanted that, they literally wanted that carve out because they felt that they needed a little bit more security to make sure that they were going to qualify said property to accept federal or state or local funding, or to create a duty on the landlord to perform any kind of reporting or a particular form of the rental agreement. They're trying to make sure that they don't have to do any kind of reporting related to these particular sources of income or a particular form of the rental agreement. I think that the realtors should be able to explain that better, but they gave that to me last night because they wanted to make sure that they weren't going to have some additional responsibilities. That's the way I interpreted it. And I went ahead and accepted that amendment so I could get them to neutral.
Thank you. I just didn't know what particular form of rental agreement is, if that has.
So, but I think that the realtors need to explain that provision because that was thrown in by them last night.
Okay, thank you. Then I guess I
But
can follow up.
but my understanding is the reporting that will be required, like any kind of additional reporting that would be associated with it. It's like trying to eliminate the burden, any additional burden, if they accept this source of income language, not putting any other additional burden on them or creating a duty to perform any kind of reporting or use a particular form of a rental agreement to say X. And because I think that what they're trying to do is, number one, use the same kind of rental agreement and then not have to do any kind of reporting associated with this kinds of source of income. That's the way I interpreted it, but they can better explain because that's how I understood it.
Thank you. I appreciate that. I can follow up after the hearing.
No, they'll probably be testifying, I think, in neutral, but you can ask. Thanks, Mackenzie.
Great, and we'll have an opportunity to continue that dialogue when they come up. If we can go next to Assemblywoman Thomas, please.
Good morning, Mr. Chair, and thank you for the opportunity to address Senator Neal and her presentation of Assembly Bill 254. I think it's a good bill, but I do have a question, and it's actually a clarifying question. I just want to know the foundation. You mentioned earlier that you, over the summer, had about 20 female felons, that you apparently had a focus group concerning this bill. I was wondering if you also included any of the male ex-felons. Thank you.
I didn't exclude. It's just that when it got put out in the space, there were majority women who joined. There was only one male, and he was literally recounting the story of another female. That was what was interesting about it. And it was with the Nevada Apartment Association. We all were on a Zoom. It's recorded if you want to watch it. And literally, we had a conversation about what was really going on in the space and the issues that they were encountering. And they were able to put in that conversation which apartment complex they had been denied access to and how this impacted them trying to re-enter the space and live their lives. And they were able to put in the information how they hadn't been able to find or live anywhere or had triple and double deposits. They also mentioned how if they had tried to find an apartment, that they went through years of denials. That was more than one story associated with the women. I didn't exclude anyone. It just so happened that women were the ones who were predominantly at the top.
Thank you.
Follow-up?
Yes, please.
Please.
So with your survey, did you take a survey? And if you did, can you share that survey?
So I did not take a survey. What I did was I had a Zoom, and then I work with Mass Liberation and some other groups in my district who brought the issue to me. So Make It Work, Mass Liberation. There's some other groups too. I'm forgetting their names, but they came to me and they had their individual stories about why this bill mattered and why it was important. And so that is how I got there. And then the other person who came to me was a pastor's wife, just like Pastor Smith's wife, who worked at Casa Grande, who then came to me also about the bill, asking me directly to deal with the issue because she was seeing firsthand what was going on at Casa Grande. And the only reason why she didn't participate in the Zoom meeting that I had is because she ended up getting freaking COVID. And so, but she literally came to me and was saying, we are housing them in Casa Grande, and they are not able to find housing. So it's almost like this hamster wheel that they're on. And that's how I got the bill. That's how I decided to do it, because of the folks who came to me in my district who literally said, this is a problem, need to deal with it. And then after I had a series of conversations, then I understood. And then I went to Professor Pendel, his expertise is in fair housing. And then he offered a couple of books, and then we're here.
One more, Chair, please, follow up.
Please, follow up.
So the professor would have the data?
Professor Pendel, I know that there's data out there. There's a lot of data out there around fair housing. Is he not on the Zoom anymore? Professor Pendel?
I think we may have lost him. If we could have, and I also see Ms. Jenkins ready to go, I think.
Ms. Jenkins, do you have?
Right, so the Nevada Equal Rights Commission does keep track of Nevada state-specific data. I'm sorry, apologies, committee. Kara Jenkins, for the record, and through you, Chair Flores, directly to the member. We do keep data. However, we have not done a great job with it because of funding. I'll say that we will work to collect more data when we can have staff to do so. Right now, when we do employment data and we capture national pictures of housing issues, we go to EEOC or we go to HUD. And HUD does break down data. When I spoke with HUD early this season about housing statistics, particularly during COVID, I will share this with the committee. Of concern to HUD was a rise in sexual harassment cases for females in housing, particularly in the state. Because when you lose a job, you lose the ability to pay rent, and in lieu of rent, certain particular landlords were exploiting women tenants. So to the extent that I can provide and get some information from HUD, I'm happy to do it. Senator Neal, give me a day or two, and I can try and get a screenshot of what HUD can give us. But essentially, I would really like the commission to be able to provide that for you all, hopefully next session. Thanks.
Thank you. That sounds like a possible bill.
What? Sexual harassment of
No, data.
So there is data out there, but not specifically from NERC, but there's anecdotal information out there. It's not even anecdotal. There's research on this topic. And so I will turn that around to the committee after the hearing. But I just don't have it with me, and I apologize for that, because I did have it at the Senate, but the Senate didn't ask me. So, but I had it. I had it ready. I had like a slew of things ready just for the data piece, because that's always a huge thing for me too.
I appreciate it, Senator. Thank you, Chair.
Thank you, Assemblywoman. Next, we'll go to Assemblywoman Anderson.
Thank you, Chair, and thank you, Senator, for bringing this forward. I really appreciated that metaphor that you just used of the hamster wheel, because it's so true, and there's so many elements of this bill that I really agree with and think that there's something for us to do. I am going to get into the weeds a little bit on some of them, if I may, but I will refer to, hopefully we'll be able to refer to specific areas. My first question has to do from page 4. I believe this is from the HUD guidelines already. It's section 14, and I don't know enough about this process, but is there any sort of whistleblower protection for the witnesses and or for the individuals who bring forward this complaint? Or is that based upon the process itself, because you want to make sure that the people making those complaints, there is whistleblower protection in some fashion.
Ms. Jenkins, go ahead.
Neil, through your chair to the member, yes, whistleblower protections are embedded in anyone filing a complaint under Title VII or housing. And so NERC investigations also have a state-specific statute to protect folks who serve as witnesses to the commission in the course of our investigation. However, once you file a complaint, and this is really important, the commission has to give due process to the entity, right? So it's either the employer or maybe it's the apartment. We have to tell them that there is a charge that has been filed. Please respond to these questions. That's part of their due process. So there does get to a point where at some juncture of our investigation, we have to notify the respondent, AKA the other party. And all the investigations are kept confidential as it relates to NERC. We are not the privilege holders of that information. The respondent, the complainant, they have to come to an agreement to share it, but usually these matters are settled confidentially, privately. That's why you don't hear a lot about these cases that we're successful in settling, and that's a good thing because we want to protect entities and we want people to be able to move forward. But yes, there are protections, however, to a point. So if you're the charging party, or I'm sorry, in HUD, they call them complainants or they call them complainants, someone filing. It's confidential until we're at the point of where we have decided that we want to proceed with an investigation. It's met prima facie elements of HUD discrimination or housing discrimination, where we need to now go to the entity that you are complaining about and ask them. That's part of their due process. So I hope that answers your question.
It does, thank you. May I have another question, Mr. Chair?
Please.
Thank you. My next question has to do with section 16 with the number of different days. And it's not the dates themselves that my question really deals with. It has more to do with, it's kind of a cross question. It has to do with both of that, but then also moving this away from HUD, which I respect, it should be in our own state, over to NERC. I'm concerned about the number of employees and whether or not this timeline can actually be utilized. Because, I mean, you've got the within 20 days after this, those sort of timeframes. Has there been any discussion about increasing the number of employees at NERC with this very strict timeline? Because you don't want to lose or not be able to bring forward a complaint because of something not being done within the time frame that is set in law. So I'm just concerned about the employee numbers and bringing it over to NERC because of that timeline.
So Dina Neal, for the record, so part of the importance of this sections in this bill is the support that NERC will get. NERC will get additional investigators if we get into substantial equivalence with HUD. It doesn't remove the opportunity. It's my understanding, Ms. Jenkins, yes, we will get beefed up, but it doesn't remove their ability to still file with HUD. It just allows them to be sourced locally in terms of the complaint. But if we adopt this language, we're going to get an additional attorney at NERC and additional investigators and potentially some other financial support. So this is super important. We have not been on the same page with HUD, which is a problem. So when we talk about trying to deal with fair housing, we have to bring this language forward in order to get to the place where we can actually handle the complaints fairly, equitably, and with enough support.
Follow up, Mr. Chair?
Please follow up.
Oh wait, it looks like Ms. Jenkins also wanted to speak before I do so.
Please, Ms. Jenkins.
Thank you, Chair Flores. This is Kara Jenkins again for the record. I just wanted to follow up with Senator Neal in saying that in order for us to partner with HUD, we have to certify, and it's a 3-year process. And we have had discussions about that for a very long time. As Senator Neal had mentioned, this has been going since 2009. And, we're the executive branch, so we can't speak to any efforts to try to get on board, but we're certainly encouraged by this. So it would take 3 years to certify with HUD, and upon certification, they would give us 4 cases. So how it goes is HUD, since we are not substantial equivalent, we're not partners with them yet. Unlike the EEOC, we partner with the EEOC. In fact, NERC's known for our complaints in employment. But with HUD, because we're not a state government partner with them yet, and folks will go to San Francisco to file, HUD maintains all those cases. They are ready to give them to us. So when I had a discussion with the director over at HUD, my counterpart, he's great. They're encouraged too. He said that they would slowly give us maybe 4 cases a month. We can do 4 cases a month. And I even spoke to our DAG on that. We had conversations with the AG's office about the ability to handle that caseload, because as you all know, right now we're at 14 FTE. COVID hit us kind of hard, but we are the mighty NERC. So we are getting cases done to the best of our ability, but we can definitely handle 4 cases a month. And if we're successful, it's a process like a ladder. We go to the next year to certify, then we go to the 3rd year. Also with the HUD dollars, we get funding so that we can train and provide outreach. So all the private industries can get the resources like we do with employers to basically prevent harassment, to prevent charges, because proactiveness is kind of our thing here. Education, preventing discrimination really helps everybody. So we get money to train, and we would be trained. So NERC would get, instead of us having to attend CLE courses or just get our secure outside training, HUD would be giving us up-to-date training on laws, protections, so that we can stay current as an agency. So, sorry, again, I try to boil down, but I get really excited about this and I end up talking. So, long story short, we would have 4 cases to start to close a month as our obligation to certify, on the road to being a full partner, and we think we can handle that.
Thank you. And a follow-up, Mr. Chair.
Please follow up.
Thank you. So I want to make sure that I'm understanding correctly, though, that NERC is under our, oh my gosh, who is ahead of them? Is it
Dieter?
Dieter? Okay, thank you. I was like, what's the right word? Dieter, which has been understaffed and incredibly overworked. At the same time, that's a different topic. So with NERC, is that a governor appointee board? So could it be can the executive director be completely changed if there's a change of governor? I mean, that's a little bit of a concern for me. Is this something that is political in nature, or is it policy in nature? Does that make sense what I'm kind of asking?
Policy in nature.
Thank you, policy in nature. Thank you, Senator Neal, for clarifying that. My next question has to do with something that you actually brought up, and it's not really a question. It's a concern. It's from page 23. And it's something that you brought up about the fact that the rental properties are basically apartments. There are no houses that are being mentioned. I guess my concern is that I do believe that there are some houses that should also be part of this. We do have some people that it is okay to rent a house. It does not always have to be an apartment. It feels like it's only apartments or multifamily areas that can be rented. So it was just asking for maybe a little bit more clarification as to why it's basically taking out the houses in the suburban areas.
Dina Neal, for the record, thank you, Assemblywoman Anderson. So for me, first of all, I never intended to include single-family housing. So when the realtors brought it up to do the exclusion, I understood that. And here's the reason. Here's my thought process and my reasoning behind that. Number one, I see, and this may open a door for the folks in opposition, but at this point, you can't make everyone happy, and I am past that and will not. So at the end of the day, I feel like private property has a total different piece for single family residents. When you extend your home to someone, I think you have the right to determine who will live within the same 4 walls of you, or who will live in a conjunction or a grandmother suite or whatever it is that you have. And I think that there are inherent property rights associated with that single family residence. It's the same thought process that I've had for a really, really long time around HOAs, right? Not trying to drag them in. But I do feel that there are distinct control and inherent rights of that property owner who has that mortgage, that 30-year mortgage on a single-family residence because of the proximity. And I know that people could say, oh, well, it's proximity of apartments. No, but I feel like a single-family residence is very different than an apartment. It is something that someone has decided they own. They have taken their hard money. It's not a commercial lending experience. And I have no idea what Airbnb does in this space, and I could care less because that has nothing to do with this bill. But I really felt strongly about that because I don't want to give the opportunity for my home. That is it's a very safe place for me. And it's not a place where I felt like I wanted to infringe upon someone's property rights there. I wanted to hold that out.
Thank you, and thank you, Mr. Chair.
Thank you. Next, we'll go to Assemblywoman Black.
Thank you. Wow, that's a lot. I was planning to go to Mr. Pindell and clarify some statements he made yesterday, but since we're on the topic of property rights, I guess we can start there. I was tracking with you as far as, keeping people out of prison and the amount of money that we invest in doing that and decreasing recidivism. We work on education. I know we've seen a couple bills this session for giving people birth certificates and state-issued IDs and signing them up for Medicaid when they get out of prison. So I would agree with you. We certainly do exhaust a lot of resources for that. And those people, when they get out, I agree, they've paid their debt to society. But what gives us the right to say to a private property owner, you have to rent to this person because the state has invested a lot of money in keeping them out of prison? I'm having a hard time tracking with that. I'm also having a hard time tracking with, you have different property rights that we don't want to infringe on in someone's home, but a property owner that owns an apartment complex has the same exact property rights as a homeowner. Whether they came by that property complex through commercial lending or private lending or cash or whatever, property rights are property rights. And what gives us the right to tell them who they can rent to? That's not discriminating against someone. That's a risk assessment. These people have a business and they have to make an assessment on who's a good risk and who's a bad risk. And what gives us the right to tell them that they can't do that?
Thank you for the question, Assemblywoman Black. So there's a couple of things in there. Number one, as a government and as a state, we actually can take state action and we can set apart a public policy purpose in order to get into this space. We are not prevented. We are not constitutionally prevented from establishing housing as a position that we would like to make reasonable accommodations for. There's a long history of, number one, property rights and the state engaging in the issue of what is reasonable accommodations and access. So in terms of a public policy purpose, I feel like we are within our rights as a legislature, number one, and as a state government, to then go in and make this public policy purpose. We are not limited at all from doing this. Your second point about distinguishing between who should have a safe place, what I am establishing and what I am saying is that there are a group of individuals who happen to be denied housing who should be treated equally. And I am making the equal argument that there is an equal application of the law to those individuals, that they have a right to housing. That's what I'm resting in, and that is the legal concept that I'm resting in. And so when we talk about the hierarchy, right, and we talk about legal terms and the hierarchy of what is an equal protection argument that I'm potentially making right here, that ex-felons should have an equal right to housing, I am making that. And I am saying that in regards to private individuals, we have seen more than once, when you think about takings by a government, right, that is an infringement upon property rights. But does it have a constitutional place? Yes, it does. Is it constitutionally protected? Yes, it is. Does the state have an ability in other frameworks around property? Can they go in and infringe Eminent domain is another place where we do that. So when you talk about property rights, there are caveats and there are places and there is a lineage there. And so what I am saying here, for sure, is that I want to use this bill to establish that these individuals have equal right to housing. And that is why I think that I can make the distinction between a single-family house and a commercial property.
Follow up?
Please follow up.
I think there's a clear difference between guaranteeing equal rights to housing for somebody on the basis of their ethnicity, their religion, their gender, their whatever those things that are out of your control are, versus somebody that chooses to go to prison because they choose to break the law. That's I would agree with you that yes, in some cases, there are cases where we should protect people's right to housing. But these people made a choice to break the law, and I believe that we don't have a place to tell a private property owner who they can and can't rent to. Whether we have done that historically or we haven't, that doesn't make it right. It just means that's what's been done. But I still think that that violates these people's property rights.
And thank you, Assemblywoman Black. And I respectfully disagree with you, and I understand the difference of opinion. However, we are in a place where you are saying they made a choice to commit a crime. And if this is the line of reasoning that we're going to go with, then why are we investing any money, a single dollar in them for reentry? Why are we, because that has been a bipartisan effort for about 15 years. So why are we investing a single dollar in the actual reentry of those individuals into society? Why have we taken on, as you stated, vouchers, birth certificates, health care? Why are we even allowing them to even be on Medicaid or engage in welfare if we're saying that they are completely lost, and because you made a choice to commit a crime, you are now in the dungeon of society? You are now no longer allowed to participate at any level in this society. Because if that is the viewpoint that we have, that because of your prior offenses, you are designated to a caste system, then we need to re-examine, number one, how we spend our government dollars. Absolutely. Because that means that we have put our dollars in a purpose that does not serve our ultimate goal. But that is not the case. We are spending millions of dollars to rehabilitate and basically re-enter those persons into society and give them a second chance. Even one of the most, and I would say, conservative states, Texas, has focused on the reentry and bipartisan way to help those individuals come back into society. And the main reason why is because the damage that is done by leaving them out of society. The damage that occurs is that you leave them homeless, which has an even greater problem on and drain on the society than housing them. And so when we balance this out, it is very important to balance out what are the needs and the goals of this state. And if we have already established that they are worthy of being serviced and being placed in Casa Grande, being placed in a halfway house, going to Hope for Prisoners, going and participating in all other aspects, then why is housing one of the places that they won't be allowed to participate in? And so if you believe something opposite of me, we can respectfully disagree, but my position is we don't live in a caste system. And we are trying to break every effort of anything that looks like a caste system or creating classes of individuals who are unequal.
Follow up?
So, members, we do have, and I will entertain another follow-up, but I just want to remind members, we have another hearing. The other hearing will have an equal amount of questions. And folk with who have opposition and support, and we have floor at 11:30. So I just wanted to make it clear that this is what we're going to do. We're going to go back to Assemblywoman Black, then we'll go to Madam Vice Chair Ellison will ask a few questions to our legal so that it can be clarified on the record, but not to Senator Neal. And then we'll go lastly to Assemblyman Matthews, and we'll close it out with that. Assemblywoman Black, please.
I agree with you 100% that housing is an issue, and I do not want people to be relegated to living in a dark hole somewhere. That's not what I'm saying. What I'm saying is I don't want it to be at the expense of people's property rights. So I think that the mechanism we disagree on, the point we do not disagree on. I want to clarify that first. But I'm going to shift gears here and just say, you know, we've been in a pandemic for over a year now. Our property owners have been on rent moratoriums, not able to collect rent. We have a huge influx of people coming from all over the country. The real estate market is insane. Another one of my concerns is putting this on to property owners right now at a time when we don't even know what's going to happen with our real estate market or our rental market, let alone imposing a bunch of new rules on these people that have not been able to collect rent for almost a year and a half. So, thank you.
So thank you for the comments, Assemblywoman Black, and I respectfully understand your position, and I appreciate the differences in opinion. However, the pandemic has hit everyone. These apartment owners also did receive government assistance to offset. There were millions of dollars of subsidies that came in the state. So whether or not people feel that it was unequal application, my main issue and argument is, would you rather them be homeless and then deal with the millions of dollars that we're spending there, where you find them in an empty lot, where you find them hovering behind some space, using the bathroom behind a restaurant? What would you prefer? Because I prefer for them to at least be able to put in an application and at least be afforded the opportunity to be equally viewed, just the same as any of us, to determine that they can have a roof over their head. This is about a roof over someone's head. Punishment is not in perpetuity. We can debate whether or not apartment complexes manage to survive and whether or not the subsidies met the need, or because there were several arguments out there that you basically allowed a bad tenant to stay in my apartment forever or for 6 months when I was literally on the verge of evicting them. But there is a larger public policy purpose that was also being established by the government. That, yes, were we all attempting to be good citizens in the pandemic? Yes, we were. And here's the reason why. Because it was far more dangerous to place those families on the street. And so we had to make a decision about whether or not we wanted to, A, place an additional burden temporarily on private owners in order to save a greater good. The greater good was a single mother and families who potentially were going to be on the street, who then what? You don't longer have milk for your kids. They don't have a bed to sleep in. It would be a far greater issue to have had that rush of individuals living out there homelessness as homeless people because the government had no ability to sustain them. Where were they going to go? Where were they going to go? We were going to build a bunch of little tiny houses in a matter of a couple of months and place them somewhere? No, we weren't going to do encampments. So yes, did the government make a decision to burden apartment owners in order to save families from a greater loss and expense, which would have been a greater loss on our state and a greater burden upon watching those families be out there? Sometimes we make social justice decisions. We do. And we do it because we are placed in a situation where there is a conundrum or an issue that we need to deal with. And so I don't want to turn this hearing into what happened during the pandemic, because my ultimate argument is that they have served their time. Punishment is not forever. And if we are not living in a caste system, and when you have decided that someone is free, they are free. And they need a right to a house. And all I'm saying is that, can I get an application and be approved? That's it. It's not deep. But for some reason, because of our ideological spaces, we have already decided that certain individuals cannot make it through. But that was the case in the 60s. Blacks weren't allowed to live in houses. There are a whole set of case law where we were literally denied for the color of our skin, and we couldn't change that. And now you're telling me, as we move into 2021, and I say that ex-felons who have served their time, who we're putting government dollars into, they are the class of individuals we have no right to touch. They have no rights in this society. And if that is the case, then keep them in prison. Because I don't understand why we're letting them out if we really feel that they have no value and they are not worthy of a roof over their heads. That is the craziest thing to me. Well, I'm not saying that you're saying that, Assemblywoman Black. What I'm saying to you is that in this discussion, I have liberally expanded my thought beyond your statements and made my own statements, which may or may not apply to what you said.
Oh, for the sake of time, I'm going to allow Ellison to please ask his questions to legal. And we're going to skip over Vice Chair at this time.
Thank you, Mr. Chairman. My question is, based on this bill, if somebody comes in and applies because of not being in prison, but damage to properties, to other properties, and to non-payment of rent history, are we setting up the private housing market to be sued or be enforced on by this bill? And my problem is the private industry is in the drink. It's in major damage. And my biggest fear is we're taking away their rights, more rights, for them to manage. And so with this bill, if they come in and said, look, I've been in prison, that's not the issue. But if they come in and they have bad history of non-payment of rent or damaged other properties prior, can they deny these people without being sued?
Ms. Jenkins, would you like to speak to that? And could you also put on the record what is currently going on within the federal housing space and what are the designated existing rights around crimes?
Well, I'm not talking about federal housing. I'm talking about public housing, private housing. That's where I'm talking about.
So, thank you, Assemblyman Ellison. Ms. Jenkins, can you please clarify what is currently the federal rules around private housing and what's currently in place? Because there are existing policies. Thank you.
Long story short, outside of any protections, and you say you don't want to rent to that person because they have a lack of a stable payment history, that's legitimate and not tied to protected category status. It's not tied to fair housing. It's a legitimate question that you'd want to ask on your rental application that has no bearing here. They would not be affected. Similarly to, I'll just parallel to employment. If you have someone who is applying for a job, but they have a criminal background, and it's a public employer, say, because that's where Ban the Box applies here in the state of Nevada, you would just see if the person could meet the essential requests of what the job is. Can this person meet our essential work functions? And outside of their criminal conviction, if say they have a background in banking, but the job is to be an artist, it's up to the person to decide to hire them or not. And if that person didn't get the job, they couldn't come to NERC asking for us to basically enforce any discrimination practices because it has nothing to do with the protected status. Senator Neal, did I make that clear? I'm not, I'm executive here, so.
Dina Neal, for the record, I'm not sure. Assemblyman Ellison, did Ms. Jenkins properly answer your question or do we need to further clarify?
My biggest fear is, these guys have not received payment for a year and a half. They're almost in bankruptcy. Some have already lost all their homes or their businesses. My biggest fear is if you have somebody that's got a bad record for non-payment or damage of people's properties, then I should have the right to deny them to rent them a home. And I think the history of that should be, it's not about their criminal history, but it is about the history of prior, say they had 5 evictions or whatever destruction. I'll give you an example. I have a Spanish family in Elko, probably have the most beautiful houses you ever saw. The people moved in, they never got a dime's rent for a year and a half, and when they finally got them out of there for destruction, $15,000 in damage to the house and $15,000 in back rent they'll never see a dime of. They should be able to write somebody else to rent them, to deny them based on that.
So, Assemblyman Ellison, a prior eviction is not precluded from this bill. I'm not.
I just want to get this on the record.
Yeah, I'm not dealing with. You've had a series of evictions, and you go and apply, and the eviction history, the apartment feels that you're a risk. You're probably a risk because they feel financially you cannot pay the rent, right? Because more than likely you're evicted. It's the same way as you lose your mortgage. You lose your mortgage and go into foreclosure because you cannot pay it. The amendment specifically says that they're allowed to look at your credit history. They're allowed to look at your income. The issue is, I'm talking about the criminal history. I'm not talking about all of the other factors that may come into play. And I understand that this bill is now becoming convoluted with all of the housing issues. But SB 254 is trying to get at, number one, bringing forward substantial equivalence by having provisions in the bill that allows us to get on the same page as HUD, adopting fair housing policy that brings in familial status, religion, also brings in support, investigative support, financial support to NERC after they certify and get in compliance. It also is opening a brand new door, which is the one that we've been debating for this extent of the hearing. It's around the criminal history. Everybody has differing opinions, but this is a first step into this issue, and I think it's a good first step. The source of income piece has caused much concern, but there's a broader question of all fights that happen, whether or not an income of a person should be protected and to what extent should it be protected. If I don't have money, but yet someone gives me a voucher, which is the equivalent of that money, should that be protected and looked at as equal value so that I can find a house? I say yes. Did I make caveats and try to work with multiple parties? Yes, I did. But the context and the gist of this bill is still intact. And if you don't support it, okay then. But I'm telling you that this is good policy for the state of Nevada. And some of this tangential issues that were brought up around the pandemic do not come into play here because these individuals, my issue is that they'd have a right to apply and have a roof over their head. And I'm just going to keep it that simple. And I'll just open myself up for additional questions. You guys are giving me the hearing I probably should have had and sent it GA. So I thank you.
Thank you, Senator. And Assemblyman Matthews, I know that we had you for a second follow-up, but would it be okay, since we allowed for you to go first, for the sake of allowing for the meeting to move, that we just take that question offline?
Yeah, that would be fine, Chair. Thank you.
Thank you, Assemblyman. And only because you already had a question on there, we just really got to get going. I want to be mindful of the other hearing that we still have to take care of. So with that, we're going to go ahead and invite those wishing to testify in support of Senate Bill 254. I don't believe we have anybody in the room for that. And so broadcast will go to the phone line, please. And we want to remind everybody to please limit your remarks to 2 minutes. If somebody's already made your argument, a quick ditto is more than perfect.
To testify in support of Senate Bill 254, please press star 9 now to take your place in the queue. Caller with the last three digits of 938, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair Flores, Vice Chair Torres, and members of the committee. For the record, my name is Ariel Edwards, ARIELLE-EDWARDS, with the City of North Las Vegas. We would like to thank Senator Neal for bringing this bill before the legislature, and we appreciate the opportunity to testify in support of Senate Bill 254. Fair housing is essential to fostering a healthy community that thrives. We know that fair housing can significantly reduce the rate of recidivism and promote healthy, thriving communities. The intent of this bill is on track with the priority of the North Las Vegas Jail to promote equity and opportunity through rehabilitation and reintroduction to society. And people who have already paid their debts to society should have an opportunity to have a dwelling of their own for them and their families. We know that these discriminatory practices disproportionately affect Black and Brown communities the most. It has been long overdue, but it is time that we move on from these discriminatory practices and ensure that housing, dignity, and respect is paid to all. We strongly urge the committee to support and pass Senate Bill 254. Thank you.
And thank you for joining us. Next caller in support of Senate Bill 254.
Caller with the last three digits of 656, please slowly state and spell your name for the record. You may begin.
Hi, good morning, Chair and members of the committee. Will Pregman with Battleborn Progress, WILL, like Peter, REGMAN. We are in strong support of SB 254. Every person deserves to have housing, regardless of their past mistakes. Still can help formerly incarcerated Nevadans re-enter society with the ability to rebuild their lives. If somebody cannot find stable housing that is within a distance of job opportunities and community structure, it can make it much harder for that person to find those new opportunities. The lack of stable housing all but guarantees recidivism. We thank Senator Neal for bringing this bill forward today and urge your support. Thank you.
And thank you for joining us. Next caller in support of Senate Bill 254.
Caller with the last three digits of 653, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning to the committee chair and vice chair and Senator Neal. Thank you so much. This is Dora Martinez, representing Nevada Disability Peer Action Coalition. Thank you for introducing the bill. I urge the committee to pass it. Thank you. Have a great day.
And thank you for joining us this morning. Next caller in support of Senate Bill 254.
Caller with the last three digits of 199, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair and members of the committee. My name is Tess Opferman, that's spelled O-P-F-E-R-M-A-N, speaking on behalf of the Nevada Women's Lobby. We are in full support of this bill, which will work to remove discriminatory barriers that prevent prior felons from securing housing. Stable housing is the foundation for safe and secure communities. Ensuring prior felons can access housing means keeping families together and creating opportunity for economic and educational growth. We thank the committee for your time this morning and ask you for your support on this bill.
And thank you for joining us. Next caller in support of Senate Bill 254.
To testify in support of Senate Bill 254, please press star 9 now to take your place in the queue. Chair, there are no more callers in support at this time.
Thank you. At this time, we'll invite those wishing to testify in opposition on Senate Bill 254. Do we have anybody in the room? Okay, and we'll go straight to the phone lines, please.
To testify in opposition to Senate Bill 254, please press star 9 now to take your place in the queue. Caller with the last three digits of 725, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hello, thank you, Chair and committee members. This is Nick Shepak, Nick Shepak with the ACLU of Nevada. I want to start by thanking Senator Neal. This legislation intends to address real problems. We have not had time to address the amendment with Senator Neal, and we did not plan to testify today. However, I want to be clear that we have been asked to put our concerns on the record for clarity, and that is why I am testifying now. Again, we appreciate Senator Neal's intent and desire to make progress in the very real housing crisis that our state is facing that disproportionately harms communities of color, low-income Nevadans, and the formerly incarcerated. However, with the carve-out that has been provided for realtors in the amendment, we believe this bill will do harm to the criminal justice reform this body is committed to pursuing. By exempting single-family homes from their fair chance provisions, the Nevada Legislature would be declaring that Nevadans with criminal records who have served their time are too dangerous to be considered for the suburbs. This distinction is dangerous. Senator Neal said during this hearing that we do not want to have an equal protections issue or create classes of persons in regards to housing. In that same vein, all tenants should have the same protections and rights, regardless of where they would like to live, so we don't create modern-day housing segregation. The most rewarding part of my job is working with currently and formerly incarcerated individuals. Many of them have violent felonies. Most violent felonies are not murder. Many have served decades in prisons and years in solitary confinement. Punishment for violent crimes are severe in this state and often include intense community supervision upon release. The ACLU of Nevada will continue to fight to ensure that those men and women have equal opportunities in Nevada. This includes housing, and equal opportunity means access to all housing, including but not limited to apartments and single-family housing. When we release people from prison, they need housing. Over 90% of the people who enter NDOC will re-enter society. Each and every one of them need housing. We thank you for the opportunity to put our concerns on the record and urge this body to take bold steps to ensure that people have equal access to housing. Thank you very much for your time.
Thank you. Next caller in opposition on Senate Bill 254. I do recognize we have somebody on Zoom. We'll finish off those on the phone line, and then we'll come back to Zoom.
To testify in opposition to Senate Bill 254, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 809, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning. My name is Gregory Peek, P-E-E-K. I am president of Ergs Properties. We're based out of Reno, Nevada, and operate apartment communities in northern Nevada. I want to first thank Senator Neal for starting this discussion, but I do want to say that I am opposed to the bill. Landlords have a duty to take reasonable steps to keep their communities safe, and this includes asking reasonable questions and doing reasonable inquiries into an applicant's background. This is reaffirmed over and over again. In 2007, the city of Reno established the crime-free multi-housing program. The mission of the Reno Police Crime-Free program is to establish a partnership with property owners and managers to improve the quality of life for citizens that reside in any form of commercial property, such as hotels, motels, apartment properties, through the use of local and other resource agencies using civil and criminal law to facilitate effective and lasting solutions. Reno's crime-free community requires background checks, and the program provides model lease language and model background checks. The city of Reno's website states the crime-free program lists benefits. Proactive property management deters 50% of crime, and careful screening at the front desk is required to deter a potential problem before it starts, and this saves time and money. More stable residents, a great resident base, and increased personal safety for residents. This is worth repeating. Careful screening deters 50% of crime. Don't take it from me, take it from the city of Reno, and I agree. Also, the U.S. Department of Housing and Urban Development has issued guidance about the use of criminal background information to determine rental eligibility. This guidance balances the landlord's obligation to keep a community safe with an individual's efforts to rehabilitate themselves. I support the federal guidance. It's good, it's workable, and it makes sense, and it's fair. Finally, during the presentation, Senator Neal made an admission that the bill would infringe on the private property rights of single-family homeowners if it were applied to single-family residences. I would suggest that the bill also infringes upon private property rights of multifamily apartment owners such as myself, and it makes it impossible for landlords to fulfill our obligation to take reasonable steps to safeguard our communities. And it infringes upon the current good law-abiding tenants' ability to have safe and quiet enjoyment of their apartment. Thank you very much.
Thank you, sir. Next caller in support of Senate, in opposition to Senate Bill 254.
Caller with the last three digits of 436. Please slowly state and spell your name for the record. You will have 2 minutes and may begin. Again, caller with the last three digits of 436. Please slowly state and spell your name for the record. You will have 2 minutes and may begin. Chair, there are no more callers in opposition at this time.
Thank you. Please let the record reflect that there were several folk who were going to call in opposition and also who are present in opposition, and they, in lieu of them coming all up and speaking for 2 minutes each, requested that we allow a couple extra minutes to our caller, or better said, our individual who's joining us via Zoom. So if we could now, IT, please go to those who are joining us via Zoom. And I believe
Sorry,
that's
I was
Ms.
waiting
Susie
for
Ed-
broad.
Yes, please.
Okay. Sorry, I was waiting for broadcast to make an announcement. Chair and committee members, my name is Susie Vasquez, and I'm the Executive Director of the Nevada State Apartment Association. First, I'd like to address the question from Assemblywoman Considine regarding screening. Our industry only accepts and evaluates one application per available unit, but not multiple, and we also use professional screening companies. This is to avoid any fair housing issues. Second, I want to clarify federal rent assistance dollars approved in December of 2020 and again in January of 2021 have been distributed by some CHAP programs in minimal sporadic payments to landlords this year. The Apartment Association opposes Senate Bill 254 despite our months and hours of work to try and reach consensus language with the sponsor. We started with work with Senator Neal last year. In fact, we participated in a roundtable and heard firsthand accounts from mostly formerly incarcerated women that struggled to find housing because of their criminal past. I personally have been impacted by people that I love who face the same issue. Unfortunately, criminal convictions carry consequences, and as an association, we owe a duty to our residents to ensure their safety. While we appreciate the sponsor's willingness to exempt some crimes, SB 254 still goes too far. An outright ban on criminal background screening means Nevada would join a very small handful of localities, Oakland, California, and Seattle, Washington, to name a few that have taken this extreme approach. As Senator Neal stated, neither the California nor the Washington legislature decided to ban the box. Some startling statistics of the consequences in Seattle include Seattle Housing Authority staff saw a 75% turnover since its law went into effect, and our industry's on-site teams will only work in pairs now to protect their safety. Evictions tripled in 2 years for residents being evicted for committing crimes. SB 254 allows landlords to evict tenants if they commit a crime on the premise. As we saw in Seattle, this policy sets some tenants up for failure. Yes, some of that will have paid their time and changed their habits will be okay, but many others will not. Yes, many in this building fear the supposed avalanche of evictions that are expected to occur once the eviction moratorium is lifted at the end of this month and its effects on access to housing. And yet SB 254 will contribute to housing barriers. SB 254 will lead to more evictions and further housing instability for the very people it is intended to protect. We submitted a letter on Nellis that represents the National Apartment Association's best practices. This guidance is in line with HUD and the Southern Nevada Regional Housing Authority guidance, which we also included. We tried unsuccessfully to have our best practices codified. We represent the good landlords and support codifying best practices, which may not necessarily be followed by all, but nonetheless represent what is right. Most notably, our best practices do not look at arrest and include a look-back period of 7 years or 3 years, depending on the crime, and also required by HUD. SB 254 has no look-back provisions. Under our guidance, if enough years have passed from the crime, a person would not be denied tenancy based on that fact. SB 254 also includes a source of income provision. We appreciate Senator Neal's amendment to exclude Section 8 vouchers. HUD is in the process of introducing Section 8 housing reform in Washington, D.C. National Apartment Association and other trade associations have worked diligently with HUD to address the issues many programs experience across the country. I would like to take this time to ask legislators to assist us in the interim with reducing barriers landlords experience with some Section 8 programs. We are committed to partnering with our housing authorities to expand the program and would appreciate any assistance you can provide. Nevada families deserve to feel safe at home. Landlords have the right to choose who they rent to as long as the practice is non-discriminatory, which under our best practices, it is not. SB 254 goes too far. It's a dangerous policy, and we urge you to oppose this measure. Thank you.
And thank you. And with that, we'll go to those wishing to testify in the neutral position on Senate Bill 254. I don't believe we have anybody in the room present. Ms. Jenkins, please. Ms. Jenkins, we can't hear you on our end.
Okay, unmuted. Sorry, technology is just not. Yeah, thank you, members. Thank you, Chair Flores and Vice Chair Torres and members of the committee. You all know me by now. I'm Kara Jenkins, Administrator of the Nevada Equal Rights Commission. We are neutral on this bill, but encouraged by it. And again, we're here to answer any questions as it relates to the substantial equivalency component. So thank you.
And thank you. At this time, we'll go to the phone lines. Anybody wishing to testify in the neutral position on Senate Bill 254?
To testify in the neutral position on Senate Bill 254, please press star 9 now to take your place in the queue. Caller, with the last 3 digits of 983, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair and members of the committee. My name is Teresa McKee, MCKEE, and I'm with Nevada Realtors. We want to thank Senator Dina Neal for working very hard with us on this bill. You've seen how difficult it really is. The Nevada Realtors stands neutral on this bill with the amendment that you can find in Nellis. Specifically, we appreciate the amendment to the definition of source of income to be paid by any federal, state, or local government entity before June 30th, 2022, including without limitation any rental assistance funds provided pursuant to federal law passed for the purposes of providing relief for the COVID-19 pandemic. Secondly, we do appreciate the amendment also that it specifically excludes Section 8 housing. And in response to Assemblywoman Toll's question, we're also pleased with the acknowledgement that nothing in this section, in this bill, would require a landlord to qualify as subject property to pass the requirements for that specific funding or create a duty on the landlord to use any kind of reporting or form. We did not want any of these programs, if a landlord is required to accept those funds, to have any additional type of reporting, any additional burden on them in receiving those funds. We thank you very much. I'll cut it off short. And again, thank you to Senator Dina Neal, and thank you, Chair and members of the committee.
And thank you. We'll go. And I know you referenced a question by Assemblywoman Tolles, but she is not a member of this committee. Just wanted to clarify that. We'll go to the next caller wishing to testify in the neutral position on Senate Bill 254.
Caller with the last three digits of 988. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning. My name is Emily Paulson, EMILYPAULSEN, and I'm the Executive Director of the Nevada Homeless Alliance. We're testifying in neutral today because we are in support of the advancement of NERC to become a HUD-qualified fair housing assistance program. We're very concerned about the amendment Senator Neal has introduced today that weaken fair housing opportunities for the very people she originally intended to help through this bill. Senator Neal, we agree fundamentally with your original intent of this bill and your passionate remarks about the need for equitable housing policy to address homelessness. But the amendments you've introduced today have taken us off track to do that. We would like to invite Senator Neal to come back to hear from the Nevadans who are impacted by housing discrimination because of their income source and conviction history and are facing homelessness and housing insecurity, as well as the organizations who are fighting to house them, to get their feedback about the amendments made to this bill today. Housing choice vouchers, also known as Section 8, are an incredibly important tool to help Nevadan families afford housing and avoid housing instability and homelessness. In Nevada, a majority of voucher holders are working families and single mothers who are women of color who don't earn a housing wage. Housing choice vouchers are intended to allow families to live in the neighborhoods of their choice, the neighborhood where good schools are located and where good paying work opportunities exist. 19 states have made it unlawful for landlords to discriminate against voucher holders to ensure this valuable and effective affordable housing tool can be fully utilized, and that these households truly have a choice as to what neighborhood they can live in and have a pathway out of poverty. Currently in Nevada, housing choice voucher holders don't have a choice to what neighborhood they can live in and face enormous challenges finding landlords willing to accept these vouchers. The exclusions in this bill reinforce and codify that landlords can freely discriminate against Nevadans with housing choice vouchers. Our state and Clark County in particular are about to receive thousands, millions of dollars in funding of additional housing choice vouchers through the American Relief Plan. This is a historic and monumental opportunity for our state. It's a shame these vouchers may not get fully utilized because the recipients will continue to face the enormous challenge of finding landlords willing to accept them due to this bill reinforcing that they can freely discriminate against them. Voucher holders have a time limit on finding a landlord willing to accept the voucher before the voucher must be returned. When these vouchers can't get used, the value is returned back to HUD and is lost to our state. Including housing choice vouchers as protected in this bill will help our state maximize this precious federal funding. Landlords benefit from vouchers because it guarantees rent. There is no data to support the voucher holders are riskier tenants. In fact, in contrast, according to a recent study by the Urban Institute, landlords receiving rental income from vouchers have fared the best in protecting their rental income investments over the last year. Of additional concern, the second chance provisions exclude single-family homes, duplexes, and fourplexes. This bill language codifies that people in receipt of rental assistance or who have a prior conviction can live here, not there, more specifically in apartments only. This is modern-day housing segregation. We can do better. We agree with Senator Neal that people with conviction histories and people in receipt of rental assistance are not less than. They should be able to have housing choice and not be limited to living in apartments only. An equitable housing policy would ensure that second chance and source of income protections apply to all landlords who have made a business out of housing people. We look forward to continuing to work with Senator Neal, and we hope we can come together to ensure this bill actually does what it is intended to do to improve equitable housing access. Thank you.
We'll go to the next caller in the neutral position on Senate Bill 254.
Chair, there are no more callers in the neutral position at this time.
Thank you. Senator Neal, any closing remarks?
It's late. I want to thank Assembly Committee on Government Affairs for hearing this bill. All hard policy is never easy. Trying to get folks on the same side is never easy. When you bring different groups together, one side hates another group likes someone else. So at the end of the day, I am going to listen to the proponents of the bill, and my conversation with them were that if I took out the source of income and just had a conversation in the interim, that it would be better served than to have bad policy walk out of the door. I'm in agreement with that. And so that would be the only section that I take out of the bill. Everything else would remain. And then continue the conversation on the source of income during the interim. It is a big ticket item. It's a hard item. And there are so many different viewpoints about what is considered, I guess, proper or improper. I understand the concerns, but I want to make the first step into it. And as we all learn, sometimes legislation takes 2 sessions, but you got to get the first part out, and then you can come back and deal with the rest. But at least establishing the foothold for SB 245 in terms of fair housing, I think moves a good step. It's not a perfect step, but it's a good step. And so I appreciate all the opposition. I also appreciate support in neutral. Thank you, Chair Flores, for hearing this bill.
Thank you. And members, I appreciate the thoughtful dialogue this morning and the ideological divide that obviously exists in this conversation. I look forward to Senator Neal continuing to work with everybody, and I'm sure the conversation will continue. With that, we'll go ahead and close out the hearing on Senate Bill 254. And I wanted to say thank you to Senator Harris, who's been very patiently waiting to do Senate Bill 150. Senator Harris, whenever you're ready.
Good morning, Chair Flores and esteemed members of the Assembly Government Affairs Committee. My name is Dallas Harris, and I represent Senate District 11, and it's my pleasure to present Senate Bill 150 to you all today. I know it's been a long morning for you all, so I'll make my best effort to keep it brief. Senate Bill 150 is what I like to call my find a place to put 'em bill. Right? This bill essentially directs localities to create some zoning to allow for tiny homes. If you are well set up and you are a larger locality, I'm going to ask you to find a place where we can allow these to be accessory dwelling units, possibly tiny home mobile parks, as well as the ability for folks to set up possibly single-family residence. If you are one of those smaller localities that maybe does their zoning a little less often and has a little less population, I'm asking you to do one of the 3. The genesis for this bill, frankly, for those of you who are interested, was my own experience. I recently moved, bought a new house, and I was thinking for a moment, maybe I wanted to buy a tiny house, right? Well, they're kind of cool, and I'm a big fan of financial independence and retiring early, the FIRE movement. And I thought this would be a great way to save on some housing and maybe downgrade my lifestyle a little bit. But as I started to look around where I could possibly put a tiny home if I bought it, I ran into a brick wall, right? They aren't currently listed as single-family housing. It is too small. It's obviously not commercial. If I want to put a foundation down, it's really not a mobile home. It doesn't fit in an RV park. And so I thought to myself, maybe there are other folks, other Nevadans, who want this option. And so I brought this bill in hopes of opening that up for people who want to live in these types of homes. I imagine once we open this up, we'll see a gamut of options, right? On one end, we have models like Hope Springs here up in the north, where you can provide wraparound services for homeless folks all in one area. All the way up to the kind of hipster, really cool, neat new thing with the chic type tiny homes, and anything in between, right? I think the possibility is really endless here. And so what I've tried to do is take the lightest of approaches, because let's be real. At the state level, we don't do zoning. I don't know anything about zoning. That is something that our local governments are best at. So I've simply asked them to find a place to put them. I've allowed them to put additional restrictions on if there are safety considerations. I'm going to allow them to decide where they should go, if there should be overlapping zoning between single-family residences or not. That is going to be completely up to the localities who are experts. I just want to make sure there is a place where these can be put for the Nevadans who want to put them somewhere. It'll be a community-driven process, of course. We've got zoning commissions all throughout the state. And I imagine that the discussions will be had at those local levels about where the best place is, if they should overlap, how many zones they should be allowed to do. And I'm perfectly fine with that. I think that's the way that the process should work. So you may hear a bit of opposition from some of the localities because, let's be honest, right? Nobody likes to be told what to do. And I think they would much prefer I allow them to do their thing and not infringe on them at all. I've heard those concerns, and I really feel that the bill before you walks that very thin line of not infringing on the locality's expertise in zoning, but also giving just a little direction and saying, hey, let's make sure Nevadans have an option. Chair Flores, if it's okay with you, I'd like to invite Matt Walker, representing the Nevada Home Builders Association, up to make a few comments, and then I'll be ready to take questions.
Perfect, thank you.
Thank you.
Mr. Walker, good morning and welcome.
Good morning, Chair Flores. Thank you so much for accommodating the hearing of Senate Bill 150 today. I'm going to speed read some very brief comments and stand ready for questions. Matt Walker, for the record, on behalf of the Southern Nevada Home Builders Association. Community development standards must be revisited regularly to ensure that requirements for developers and property owners meet the needs of the community. One area where we clearly are falling short is access to affordable home ownership. Senate Bill 150 urges local governments to follow the leads of states and municipalities across the country that have adopted policies to open existing residential communities to the development of new accessory dwelling units and tiny home communities. This bill addresses key obstacles to affordability: minimum lot size, minimum home size, and density restrictions. Tiny home and accessory dwelling units hold great promise in allowing the market to provide new units available to more Nevadans, while also meeting our goals for greenhouse gas emissions and housing affordability. The association strongly supports the bill, also referencing the International Residential Code as the best practice for determining how stick-built houses are built. We think it makes sense for local governments to allow for accessory dwelling units in residential districts, and it makes sense to adopt these international best practices. We appreciate Senator Harris bringing this important conversation forward. Thank you.
Thank you, Mr. Walker. I think you were giving our amazing Susan Furlong a run for her money there. Appreciate the speed reading. With that, members, we'll open it up for questions. We'll start off first with Assemblyman Ellison. Members, I ask that if somebody's already asked a very similar question to yours, that we don't repeat them, and that you try to stick to a question so that we give everybody an opportunity to at least get one on the record. So we'll first start with Assemblyman Ellison.
Thank you. And Senator, didn't they just build some of these in Reno, in the little community, and they had the little walkways, and they had the downstairs and then the upstairs above it, and it was a real small house, but they were based on about a half size of what a regular apartment would be. But God, they were gorgeous, and the parking, there was more parking than was houses, but it was amazing how they looked, and the prices were affordable for young couples. And I thought it was the greatest thing in the world, but not all communities allow it to do it based on the size of the lots and stuff. But I thought it was a great idea, and just to watch them to go up, and they look like little miniature towns. They haven't even had little miniature shops in there. So, but thank you.
No, thank you for the comment, Assemblyman Ellison. Yes, I'll say Reno is leading in this area, and I would love to see a bit more of that throughout the state. What you're speaking about is one of the potential benefits, I think, of allowing tiny homes, and that is creating this kind of intermediary step For those folks who do not have 20% of 350,000 or whatever the median house price is, right, to get a step up into home ownership, something they can enjoy and love, build some equity in, and then possibly move into a more traditional home if they so choose. So thank you.
Next, we'll go to Madam Vice Chair.
Thank you, Chair, and I promise to keep my question teensy-wincy as we talk about the tiny homes throughout Nevada. And so I just wanted some clarifying information. So my understanding right now is that a county whose population is over 100,000, those populate, like when we're looking at that specific section in Section 1, Subsection 1, that would be applicable to only Washoe, Clark, Reno, Henderson, and Vegas, right? And then requiring those jurisdictions to make those ordinances?
Thank you for the question, Vice Chair Torres, to you through Chair Flores. Dallas Harris for the record, yes.
Okay, and then in subsection 2, it would require that Section 1, subsection 2, it would require that there is that the other jurisdictions would then choose one of the options that is enumerated there below, A, B, or C, and that they would have to choose one of those. They wouldn't have to do all three of them. Is that correct?
Thank you for the question, Vice Chair Torres. To you through Chair Flores, Dallas Harris for the record, yes, that is correct. What you see is a compromise, a discussion that I had with some of those smaller localities who were a bit worried about having to find a place for all three. And so I said, all right, the big guys need to figure out how to do all three. For those small folks, let's at least just figure out a place to put one of the three, and it'll be completely up to them.
Perfect, thank you. And just one quick itsy-bitsy follow-up, if I may. I just want to understand, what the intent, it seems that several of the jurisdictions have already made taken those steps to have these ordinances. And my understanding, I think Clark, we have one, or maybe the jurisdictions within Clark County have some. So I'm just wondering what the reasoning is behind requiring it instead of just allowing for local jurisdictions to make that decision on their own.
Thank you for the question, Vice Chair Torres. To you through Chair Flores, Dallas Harris for the record. It's my understanding that in Clark County, the only one we have was set up by Tony Shea of Zappos. And I believe that is a function of his ability to have gobs of money and do something that's kind of outside of the standard zoning. For your average person, you can't go buy a plot of land anywhere in Clark County, not to my understanding, and set up a tiny home if you so choose. And so the idea really is to take that opportunity that's available to some folks in Reno and make sure it's available to everybody across the state.
Thank you for that, Madam Vice Chair. Members, any additional questions? We'll go first to Assemblywoman Thomas, and then we'll make our way to Assemblywoman
Anderson.
Anderson, excuse me. My apologies. Please.
Thank you, Chair. I just have a small question in reference to the teeny house, and you put in here single-family dwelling. What does that entail? I mean, is that a family of 4?
Thank you for the question, Assemblywoman Thomas. To you through Chair Flores, Dallas Harris for the record. That's really a zoning term, right? And so where you want to make sure that someone, and I believe under this framework, localities would be able to restrict how many occupants can be in a tiny home. But really, it's about the ability for you to build a tiny home and live in it as your primary residence. That's the connection between that and the term single-family home here in this bill.
Thank you.
Thank you, Assemblywoman. Next, we'll go to Assemblywoman Anderson, please.
Thank you, Chair Flores. Thank you, Senator, for bringing this forward. My question has to do with Section 1. It's the details of the change of verb. When it starts off with on line 5, shall, which means it has to be, and then A through C, and then even when we go into next number 2, A through C, it becomes may. So that confusion of you have to versus you may do it. Just wondering if there's a reason why that's not consistent, or if there was some other reasoning behind that language choice.
Thank you for the question, Assemblywoman Anderson, to you through Chair Flores, Dallas Harris for the record. So the shalls are related to which zones you must actually find a place to designate, right? And so in Section 1, subsection 1, we're talking about those larger folks who need to find a place for all three, okay? In Section 1, subsection 2, we address the smaller localities who need to find one of the three. And then when you move down to Section 1, subsection 3, what I'm doing here is authorizing localities to add on additional requirements if they so choose. And so I'm not going to require them to include other requirements for tiny homes if they don't want to, but I am going to enable them to do so, as well as give them the ability to continue to have jurisdiction over the certificates of occupancy, again, getting back to Assemblywoman Thomas's question. So that's a distinction there.
Thank you for that clarification, and thank you, Mr. Chair Flores.
I deserve that one. Thank you, Assemblywoman. I don't believe we have any additional questions. We do. Assemblywoman Dickman, please.
Thank you, Chair. I just want to say, if we had more time, I'd talk about how much I like this idea, but we don't. So thanks, Chair. And thanks, Senator Harris.
We'll let the record reflect Assemblywoman Dickman is all on board for it. Thank you.
Not only that, but she will work on whipping all the votes for you.
Amen. Counting on it.
Members, I want to make sure that nobody has any additional questions. All right, we'll close it off with Assemblyman Ellison.
Yeah, is there any reason you restricted it from 100,000 and above versus the smaller ones? Because you look at some of these smaller communities or like mining or whatever that are building, like several different units, they could still buy like a two-person house for mining or something. It might have been a good idea for some of these areas to do that in, so.
Thank you for the question, Assemblyman Ellison, to you through Chair Flores, Dallas Harris for the record. I agree. The bill in its original form would have required all three across the state, but after discussions with some of the folks who represent those smaller jurisdictions, they were worried about the kind of heavy lift it might be to zone all three types in those smaller towns. It would be my hope that they would do all three, and I think this bill would enable them to, but they would not be in violation of the law as long as they find one.
All right, thank you. At this time, I'll go to those wishing to testify in support of Senate Bill 150. I don't believe we have anybody present, and I don't think we have anybody via Zoom. We'll go to the phones. I want to remind you to please limit your remarks to 2 minutes.
To testify in support of Senate Bill 150, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 528, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair and members of the committee. For the record, my name is Barry Gold, BARRYGOLD, and I am the Director of Government Relations for AARP Nevada. People of all ages need safe, decent, and affordable housing that will enable them to live safely in their home and communities as they get older. Nevada has a problem with the availability and access to affordable housing. We must create opportunities to increase affordable housing, and this bill offers a unique way to do that. Nevada families of all ages have suffered during the pandemic, and we need to provide housing costs that allow individuals and families to live in a neighborhood without sacrificing other basic necessities such as food and health care. That is often the choice people make when their housing costs are not affordable. The concept of tiny houses is sweeping the country, and more people are finding this to be a great way to modernize their lifestyle. Creating opportunities for tiny house developments will offer more people the chance to take advantage of this new idea and to save money on housing costs. This will expand the opportunity to provide affordable housing in Nevada. Older adults who are often on fixed incomes can become homeless if they are priced out of their housing. We must make sure our parents and grandparents can stay in their communities and live comfortably. Tiny houses are the newest and most unique and creative way to do that. AERP, on behalf of the 345,000 members across the state, support SB 150 and urge the committee to pass it to help ensure more of this unique type of affordable housing is available in Nevada. Thank you.
And thank you. And I want to remind folk that if you really support tiny houses, tiny statements will be the best way to honor that spirit. Next caller in support of Senate Bill 150.
To testify in support of Senate Bill 150, please press star 9 now to take your place in the queue. Chair, there are no more callers in support at this time.
That is great. Okay. Now we will go to those wishing to speak in opposition to Senate Bill 150. Good morning, sir, and we'll start here in the committee room, whenever you're ready.
Thank you, Chair Flores, Vice Chair Torres, for allowing my statement of opposition. My name is Wesley Harper, and I am the Executive Director of the Nevada League of Cities and Municipalities. The League is respectfully but strongly in opposition to SB 150 as amended. We do appreciate the discussion, the work and collaboration of Senator Harris to bring this bill forward, and the distinguished members of the Assembly Committee for Government Affairs for hearing it. The mandates contained in this bill, while seeking a progressive outcome, is an affront to the ability of member municipalities to develop zoning ordinances that are proper and appropriate for our jurisdictions. I submit that decisions concerning zoning are at the very heart of matters of local concern, and that zoning primarily affects and impacts areas located within each municipality. On this basis alone, this bill is an overreach, and moreover, proposed legislation such as this creates damaging precedent for future proposed legislation that may attempt to further erode the ability of municipalities to be responsive to the residents that we serve. We hope that the committee assesses this bill with a keen scrutiny and respects the purview of local governments to properly govern according to the direct and unique needs of our residents. Again, thank you very much, Mr. Chair, for your attention, for allowing my statement of opposition.
And thank you. I know you had the opportunity to reach out with a lot of folks, so thank you for the work that you put in ahead of the hearing.
Thank you, Mr. Chair.
We don't have anybody else wishing to testify in opposition here, so at this time we'll go to the phone lines.
To testify in opposition to Senate Bill 150, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 666. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Mr. Chair, members of the committee. Warren Hardy, W-A-R-R-E-N, last name Hardy, H-A-R-D-Y. Today representing the Urban Consortium, which is made up of the cities of Las Vegas, Reno, Henderson, and Sparks, and also today representing the city of Mesquite. This is one of those tough ones, Mr. Chair, because I really can't think of any way Senator Harris could have been more accommodating in listening to our concerns and taking to heart the concerns we had. Just like the legislature, our local governments and the elected officials at the local level grapple with affordable housing every day. It's a top priority for our folks at the local level. And so this is a difficult piece of legislation to oppose, particularly because what Senator Harris is requesting is reasonable, and as I said, she's been extraordinarily accommodating. And this is an issue that is important at every level. And it's not the idea or the concept that we oppose, it's the process that we have some concerns with. And at the end of the day, we just sort of reached a philosophical divide in terms of where this responsibility should appropriately lie. And at the local level, with Senator Harris's support and emphasis on this, we will continue to work on this. At the end of the day, we do think that the requirement in statute is problematic from a precedent perspective, and as well as we do believe that requiring all three types of housing is problematic in allowing us to respond and react to the needs of our constituents at home. So with that, Mr. Chairman, I appreciate the time, and I want to thank Senator Harris again. As I said, I don't know how she could have been more accommodating. We just reached a philosophical divide at the end. Thank you, Mr. Chair.
Thank you, Mr. Hardy. And may I say, when we heard 666, we thought it'd be the devil himself. Turns out it was much, much worse. Thank you for joining us this morning, sir. And I appreciate you allowing us to joke a bit. We'll continue with those. We'll continue with those wishing to testify in opposition to Senate Bill 150.
To testify in opposition to Senate Bill 150, please press star 9 now to take your place in the queue. Chair, there are no more callers in opposition at this time.
Thank you. And at this time, we'll go to those wishing to testify in the neutral position on Senate Bill 150. We have no one present, so we'll go back to the phone lines.
To testify in the neutral position on Senate Bill 150, please press star 9 now to take your place in the queue. Caller with the last three digits of 229, please slowly state and spell your name for the record. You may begin.
Good morning, Chair and Committee. I am Jamie Rodriguez. That's spelled JamieRodriguez. I'm the Government Affairs Manager for Washoe County. I want to start by thanking the bill sponsor for working with us on the other side to address our concerns for the bill as is now drafted. We are here neutral today because as the bill is drafted, Washoe County would already be in compliance as we do allow tiny homes, in different portions under these zoning definitions in Washoe County. So just want to be on the record thanking her for working with us with our concerns with the bill as originally drafted. And again, Washoe County would already be in compliance with the bill as drafted. Thank you.
And thank you. We'll continue with those wishing to testify in the neutral position, Senate Bill 150.
Caller with the last three digits of 978, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair Flores. Joanna Jacob, JOANNA-JACOB, Government Affairs Manager for Clark County. We are neutral today, Chair. I'll keep it very brief. We worked with Senator Harris on this bill in the Senate side. While it does mandate that we find a place for tiny homes in Clark County, it is a mandate in the loosest sense of the world because she gives us options to designate local zoning, something that was very important to Clark County. As we have launched an effort called Transform Clark County, we are engaged in a complete rewrite of our master plan and our development code. So it's the timeliness of this is appropriate. That we will be able to find a place for these types of structures in Clark County, and we committed to Senator Harris that we will do so. So we worked with her to get us to neutral. Thank you, Senator Harris, for your work on this, and we are neutral today. Chair Flores, thank you.
And thank you for joining us. Next caller in the neutral position, Senate Bill 150.
Caller with the last three digits of 863, please slowly state and spell your name for the record. You may begin.
Good morning, Chair Flores and committee members. Dagny Stapleton, DAGNY-STAPLETON, Executive Director of NACO, the Nevada Association of Counties. I just want to echo the comments of Clark and Washoe counties. We very much appreciate the senator working with counties on this bill on the other side. We did work with her on language that's now in the reprint. We understand her intent and the important addition that tiny homes can make to Nevada's housing stock. We want to thank her for the language in the reprint that gives us a little more local flexibility, especially for smaller counties. And as you have heard, land use planning and zoning are local responsibilities, very important ones for local governments. So that flexibility is important to allow us to tailor ordinances based on differences in geography, community need, and other factors. Again, thanks to Senator Harris as well as the committee for the opportunity to provide comment.
And thank you for joining us. Next caller in the neutral position, Senate Bill 150.
Caller with the last three digits of 938, please slowly state and spell your name for the record. You may begin.
Good morning, Chair Flores, Vice Chair Torres, and members of the committee. My name is Ariel Edwards, ARIELLE, EDWARDS, Government Affairs Specialist with the City of North Las Vegas. The City of North Las Vegas is neutral on Senate Bill 150 and would like to thank Senator Harris for working with us on this piece of legislation. Thank you so much for your time and consideration today.
And thank you for joining us. Next caller, in the neutral position, Senate Bill 150.
To testify in the neutral position on Senate Bill 150, please press star 9 now to take your place in the queue. Chair, there are no more callers in the neutral position at this time.
Thank you. Senator, any closing remarks you may have?
Thank you so much, Chair Flores, for squeezing me in. No one likes to follow Senator Neal, so I hope I did okay. Just in closing, I'll remind you all, this is a very light touch. It is still a touch, though, right? And some people don't like to be told what to do, and I understand that, and I took that into consideration. And I really tried my best to walk that line of giving some direction, but of course allowing the localities to do what they do best. And so I hope the committee will take some time to consider work sessioning this bill. Thank you all so much.
Thank you, Senator, for that presentation. And with that, we'll go ahead and close out the hearing on Senate Bill 150. And before we close it out, I know Madam Vice Chair have some quick remarks. Excuse me, I did forget public comment. If we could please first go to public comment, I want to remind you that this is not a time for you to reopen a debate on any previously heard matter here. This is a time for you to speak about general matters that fall within the purview of our committee. Please do not try to reopen a hearing. If you do, I'm going to have to cut you off. Broadcast, we have no one here. We could please go to the lines for public comment.
To take place in the public comment queue, please press star 9 now. Caller with the last 3 digits of 556, please slowly state and spell your name for the record. You may begin.
Anne Marie Grant, ANNEMARIEGRANT, sister of Thomas Purdy, who was murdered by Reno Police and Washoe County Sheriff's Office during a mental health crisis. Today I'd like to talk about Stanley Gibson, who was killed 12/12/2011 by LVMPD. Stanley was born in Las Vegas and was a lifelong resident. He served in the U.S. Army during the First Gulf War. He was a decorated soldier receiving medals, including the Army Good Conduct Medal, the Army Service Ribbon, Saudi Arabia, Kuwait Liberation Medal, Southwest Asia Medal, and the National Defense Service Medal. He had an honorable discharge. His mother had to bury her son. His wife had to bury her partner of 11 years. Not only do police murders of community members weaken the public's trust in law enforcement, but it is the community and the taxpayers who ultimately pay for these bad actors. Stanley was 43 years old when he was shot and killed by LVMPD officer Jesus Arevalo in the early morning hours of 12/12/2011. An inferior police plan to force Stanley out of his car led to the shooting. The officer erroneously thought he was being shot at and returned fire. He fired 7 times. His wife, Rhonda, said he suffered from post-traumatic stress disorder from his time proudly and bravely serving our country during the Gulf War. Stanley Gibson was unarmed. His jacket would later be returned to his wife, riddled with bullet holes and his service medal still attached. I don't think the general public is aware of how often veterans are killed in crisis by police. Stanley was killed less than 2 years after 21-year-old unarmed Trayvon Cole was shot by LVMPD in his apartment bathroom. Stanley's murder is a perfect example of how the mental health care system failed. Stanley had been arrested 2 days prior and was ordered to have a psych eval done at the jail. That never took place and he was released. These unnecessary murders by police have been occurring far too long in Nevada. I would just like to mention Ronald Haas was killed 5/4/2020 by RPD and SPD. Washoe DA Chris Hicks is yet to release his OIS report over a year later. His family and the community wait for the report and the body cam footage. Please support bills that promote transparency and accountability from law enforcement. Thank you.
And as always, thank you for joining us, and thank you for sharing your story. With that, we'll go to the next caller wishing to join us for public comment.
Chair, the public line is open and working, but there are no more callers at this time.
Thank you. And then next, we'll go to some closing remarks by Madam Vice Chair.
Thank you, Chair. And I wanted to make sure that the Government Affairs Committee took the opportunity to celebrate our Nevada Teacher of the Year, Ms. Juliana Urtube, for winning the National Teacher of the Year. It's very exciting. She is the first Nevada teacher to win this honor, and she was celebrated today with Dr. Joe Biden, and we're so excited and so proud to have her as an educator in Nevada and in West Las Vegas.
And then I think, members, I don't know that you all knew this, but a little birdie whispered into my ear that our very own colleague, Ms. Brown May, today is celebrating her birthday. And so I just wanted to say it's an honor to serve alongside of you. Thank you for stepping up to your role. It's been a pleasure to have you in this committee, and just we wish you the very best of birthdays, and thank you for being here. Happy birthday. Members, as you all know, we will not be meeting tomorrow. Please, and I know Mr. Ellison will be meeting here by himself if anybody wants to join him, off the record. But for those of you who, I ask that you just please tomorrow pay close attention. We'll be uploading an agenda. Next week will be very heavy on work session documents. So just get ready, give yourself an opportunity to go back and review your notes. And with that, this meeting's adjourned.